Subuni sir.
Hello, on behalf of Mr. H.N. Mahapadra.
अरे से स्पीकर मध्ये काम करेल. ऑनलाइन. को मैटर आपण चाहू सर केते नंबर 6
अच्छा
आपणकर सर केते 38 हां सेटा अपेक्षा पेज वाइज वी आर गोइंग बर्तमान 1 रु 9 जाय जायछु 1 रु 9 आपण को ना सर
शुभेंदु सेनापति.
मिस्टर सेनापति
Aye.
Say Senapati on behalf of Udananda Mahapatra, H.N. Mahapatra for the petitioner. The matter was heard at length on 16/4/26. The facts and the legal issues were noted.
Aye.
Petitioner had adjournment. Lord Counsel for the petitioner has had adjournment, had HAD to address, referring to the said issues. Today, the matter being in the list for fresh admission is mentioned at the beginning of the day's proceeding by the Learned Counsel for the on behalf of Learned Counsel for the petitioner seeking adjournment. Stop. Para so para accordingly to grant further opportunity to the petitioner. The matter shall be listed for fresh admission in the week commencing
on
30/6/2026. और 38/31 पहुंचले ହେଲା
Phase 2 10 to 19
item 11 year lord.
तो HK Mahanta for the petitioner. आड़ा क्लेंथन 12/3 कर देबे.
Your lordship directed to file affidavit. Affidavit is not ready.
12/3.
My lord,
Thereafter was adjourned on 10/4. The Learned Counsel referring to the paragraph 4 of the order dated 12/3/2026 seeks further time on behalf of the petitioners. As the affidavit is yet to be filed. Stop. Para to grant further opportunity to the petitioner. The matter shall be listed for fresh admission in the week commencing 6/7. प्रथम order सेटा चेंज होची.
item 13 on behalf of Mr. Item
Item अपेक्षा करे पड़े.
13
13
Yes.
13
on behalf of Mr. Nigam.
आपण ना सर
MD Irfan sir.
मोहम्मद इरफान for the
Adjourn.
आपण पावर नहीं
नहीं मो पावर नहीं सर on behalf of
इमामुद्दीन को पावर है इमामुद्दीन.
आइए.
There Mr. Mohammed Irfan on behalf of PK Nigam
My lord.
for the petitioner. The matter was heard at some length on 16/4/2026. The propositions of law were noted. The Learned Counsel for the petitioner had adjournment to address. Stop. Today, the matter being in the list for fresh admission is mentioned on behalf of the Learned Counsel for the petitioner seeking adjournment. Stop. To grant further opportunity to the petitioner list in the week commencing 6/7. List for fresh admission in the week commencing 6/7/2026.
Hon'Ble.
Item 19, Your Lordship.
19.
Yes, Your Lordship. We were to file an objection.
To limitation.
Yes, Your Lordship.
19 actually state appellant.
Yes, Your Lordship. I'm appearing for the opposition.
Mr. Prem Kumar Mahanti for the appellant.
no my lord it's
Sorry.
it's Prabhu.
Mr. Prabhu Prasanna Behra for the appellant. AC.
Refer and further.
Other side को टिके. अच्छा आपण ही you are the other side. Sorry.
Opposite party.
Ms. Charvi on behalf of S. Rautre. What is the good name of younger Mr. Rautre?
Shubhadatta Rautra.
Yes, S. Rautre for the respondent. The Lorded Counsel for the petitioner seeks further time to file objection to the IA, seeking condonation of delay.
State has filed for condonation of delay. We will be filing an
Yes.
objection.
Respondent लिख देता. Appellant लिख के रख देगी. Oh, respondent, yes. The counsel for the respondent seeks further time to file objection to the IA, seeking condonation of delay after vacation.
Yes, Your Lordship.
Accordingly, the matter shall be listed for orders
We commencing 13/7.
in the week commencing 13/7/2026. Objection to the IA be filed, copy be served upon serving copy thereof on the Lorded Counsel for the appellants. Lorded ASC for the appellants.
Much obliged, Your
Sir,
Lord.
Item 15, my lords.
ଆପଣଙ୍କର
Item 36.
33 ବସ ବସ
Page
15
3,
ଆରେ ପେଜ 3 ସେ 15 ବୁଝ ଆପଣ ପେଜ 3 କହୁଛ 15
my lords.
ଆପଣଙ୍କ ନାଁ ସାର୍
Anubhav Moharana.
ମିଷ୍ଟର ଏ ମହାରଣା ଫର ଦ ପିଟିସନର 15 ଲେ The matter was heard at length on 1/5/2026. The facts as well as the legal issues were noted. The Lorded Counsel for the petitioner had adjournment to address stuff. Today, the matter being in the list, the matter being having been listed for fresh admission is mentioned by the Lorded Counsel for the petitioner seeking adjournment. Stop. Para. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing 6/7/2026.
Obliged, my lords.
Yes.
Page 3, 22, 31.
My lord, 24, 25. Both of these appeals have been filed by my learned senior, Lord, 24 and 25.
24 and 25.
My lord.
Okay.
Here, I have instruction, my lord, for respondent number 2 for the project proponent. I'll appear in this case, my lord. Let the copy be served on us.
So Jenna is
I have word with learned senior. He will say that
okay.
he had said that he will be appearing.
Okay.
He will serve me today. His
Whenever he appears, sir.
my lord.
So when do you file Vokalatnam?
I have instruction, my lord. I'll file within a week, my lord. Lord's my
In
grant,
7 days, 7 working days.
my lord. Both of the appeal.
Mr. Pravin Das will be appearing. Okay.
Lord's my indicate my senior. So,
But this is cannot file Vokalatnam.
no, my lord. I just
You
said
will be.
the appearance.
OP. Sorry, respondent.
Respondent 2.
Okay.
Paradip Hospital.
Okay, date करो.
We commencing 13/7.
13/7 week.
My
for
lord.
orders. Did you serve copies on railways?
My lord. My lord.
That Mr.
My-
Lorded
I-
DSGI was requesting.
I've got
for-
the receipts also.
Okay.
To
You
the
file that.
to the council.
Or you
for-
can hand it over to the postmaster to be tagged to the
my lord,
file.
I'll file it today. Today.
Because those are to be pronounced.
No, my lord. True.
Yes, please.
Yeah.
Yes.
My lord.
Page 4, 32 to 40.
Madam, item 36, madam.
Yes.
After vacation. I have appealed with the consent of the previous law. That is there.
36 ଆପଣ ପିଟିସନର କଣ ପାଇଁ?
Madam,
ଆପଣ 36 ରେ ପିଟିସନର କଣ ପାଇଁ?
a petition of.
ଠିକ ଅଛି। ସେ ଡେଟ୍ କରିଦିଅନ୍ତୁ।
Madam, Surjanarayan Mishra.
ଆପଣଙ୍କ ପାୱାର ତ ଅଛି ସାର୍।
With the consent of the previous law, I am not
ପ୍ରିଭିୟସ୍ କିଏ ଆପିୟର କରୁଥିଲେ?
approved.
ନା କଣ ସାର୍?
Surjanarayan Mishra.
ଆରେ ଆଜ୍ଞା ଆଗରୁ ଯିଏ ଆପିୟର କରୁଥିଲେ ତାଙ୍କ ନାଁ ସାର୍।
ତାଙ୍କ ନାଁ ହଉଛି
ଅଙ୍କନ ପଣ୍ଡା।
ପଣ୍ଡା।
ଠିକ ଅଛି ତାଙ୍କ ନାଁ ସେ ପଢିଲେ ଅର୍ଡର ହବ। କେବେ ଡେଟ୍ କଲେ?
We commencing 27.
27 ରେ ଆସିବ। ଆପଣଙ୍କ ମ୍ୟାଟର ସାର୍? 38. What is the other side? Other side କୁ କୁହନ୍ତୁ। Without informing, you seek the adjournment from the other side, not from the court.
Final hearing was.
Whatever, sir, how can I preempt him? It may not reach, that's another way, but please inform.
Site, sir, Pauli to accident.
Sita, I can't help you. You want that I will assist you in informing the other side.
No.
That you said clearly.
No,
sir.
man.
Then how can
My prayer is for.
your prayer has to be in the consent of the other side? Say after notice matter.
Don't call you. After vacation.
Because I don't know. No, I can't adjourn na. ଆପଣ mention mark କରୁଛି. ତାଙ୍କର କ'ଣ କହିବାର ଅଛି ମତେ ଶୁଣେ. I can't preempt them. ଆପଣ ଯେହେତୁ ତାଙ୍କୁ କହି ନାହାନ୍ତି, I cannot preempt the other side.
ଦେଖାହେଲେନି ତ
ମୁଁ ଦେଖା କରିପାରିବିନି ତାଙ୍କୁ ଯାଇକି. Sir, whatever should be relevant, please mention that.
Yes,
sir, ଦେଖା ହେଇନି ମୁଁ କହିବି ଏଗୁଡ଼ା କହିଲେ what I can do.
Yes, ma'am.
If you want that, I will assist. Then I will think about it whether the court should do that.
No.
But that should be clear prayer on your behalf that I have the court has to inform the other side, which is of course outlandish, but still then I can do that. Date କରିଥାନ୍ତ, but subject to their accepting it.
We consider 20 sir.
27 ଆସିବ. Call the list.
Item 1.
Supplementary is good.
In this matter, already.
ଗୋଟେ ଲିଷ୍ଟ ଏଠି ତ ଗୋଟେ ଲିଷ୍ଟ ଅଛି.
Item 9,
ଟଙ୍କା ହେଇଥିଲା ଆପଣ ତ ଥିଲେ.
the prep after vacation, man.
ମିଷ୍ଟର ମନୋରଞ୍ଜନ ଆଚାର୍ଯ୍ୟ 9 ଲେଖନ୍ତୁ. ମିଷ୍ଟର ମନୋରଞ୍ଜନ ଆଚାର୍ଯ୍ୟ ଆପଣଙ୍କର କେତେଟା ହେଇଗଲାଣି? 10ଟା ଖଣ୍ଡେ ହେଇଗଲାଣି. ଶିଖିଲା ଦିନରୁ କୋଉଟା ସେ ତ ଉପରଟା ଗୋଟେ ଅର୍ଡର୍ସ ମ୍ୟାଟର ବି ଅଛି, ସେଟା ମୁଁ ଡାକିବି ପଢିଲେ. Mr. Manoranjan Acharya for the petitioner. The matter was heard on 13/2/2024. Then adjourned by the petitioner on 17/3/2024 and 17/4/2024. Stop. Today the matter being in the list for fresh admission is mentioned by the learned counsel for the petitioner seeking adjournment. Further adjournment. Stop. Para. To grant further opportunity to the petitioner. List in the week commencing. List for fresh admission in the week commencing.
On 3/6.
On 3/6, Mr. Acharya.
Again?
On 3 June, sir.
July 1st to get a
What date I think? July 1st. 13/7 है.
6 sir.
6/7. We commencing 6/7/2024. 6/7 ଆପଣ 84 ଟା ରଖିଲେ. Already today. ଆହୁରି 2 ସପ୍ତାହ ପରେ ଅଛି କୋର୍ଟ. ଠିକ ଅଛି 6/7.
In item 1, your lordship, already I have filed the rejoinder and I am submitting the copy of the rejoinder to my learned friend, learned senior.
Mr. Niranjan Naik.
Yes, I
The
am
petitioner.
I am for the petitioner. I am supplying the copy
ଆପଣ
of.
Niranjan Naik.
Yes, your lordship.
I'm sorry. I forgot. I thought some.
I am
Mr.
supplying-
Niranjan Naik for the petitioner. Mr. Kabir. Mr. Prem. Mr. Prabhu or Prem.
I'm.
What happened to you? You have suffered from allergy.
No. Yes, it's allergy.
Sir, the lawyer will say everything, no to everything.
No.
That should not.
I'm suffering from allergy
So have
due
some,
to dye of my hair.
you should not leave it. It is a high risk. Please don't mind.
Right.
You are appearing, Mr. Mohanty?
Yes, I am.
So Prem Kumar Mohanty for opposite parties, 1,
1 to
1 to 3.
1, 3.
1 to 3, Your Lordship.
1 to 3.
Niranjan appearance like na? Then Mr. Kabir Kumar Jena for the
OP4.
P4.
Yeah.
5 K Nandi.
No.
5 flat. Na notice any.
Notice service.
Notice sufficient.
5 over notice sufficient. So 5 non-make. 5 non. Is submitted by the Lord Counsel for the petitioner that he has filed rejoinder to the counter of the state concern.
Filed by the state. Counter filed by the
Counter
state.
filed by the state.
Yes, Your Lordship.
1 to 5 केमते ହେଇଗଲା ଭୁଲ ଲେଖା ନା
बोल ले.
भूल से लिखते हैं कि
अरे ଆପଣ ବି sir Mahanti, what you have done, you are appearing from 1 to 3 ଆପଣ ଲେଖିଦେଲେ ତାକୁ 1 to 5
3 and 5.
correction କରିଦେବେ
1 to 3 and 5.
ଆଗ first ଲେଖନ୍ତୁ opening sentence. It is submitted by the learned additional standing counsel that inadvertently counter on behalf of the OP number 1 TO23 1213 कर दियंतु has been filed by the DEO and DPC समग्र शिक्षा मतलब पूरा लिखो शॉर्ट रे लिखो तुम देखिए लिखते पेज 46 डिस्ट्रिक्ट एजुकेशन ऑफिसर एंड डिस्ट्रिक्ट प्रोजेक्ट कोऑर्डिनेटर समग्र शिक्षा जाजपुर comma wherein comma inadvertently the opposite party number has been mentioned as 125 instead of 1TO23 1TO25 instead of 1TO23 he seeks leave to correct the same by carrying out necessary correction in the counter affidavit. Stop prayer is allowed. Correction shall be carried out which shall bear the initials of the learned additional standing counsel and to be countersigned by the court master. No, either ଆପଣ ତ ହଁ that to be countersigned by the court master. Pursuant to order. ଆପଣ ଇରେ ବି correction କରିବେ ତା ପରେ ଲେଖିବେ ପରେ ଲେଖିବେ by the Lord Counsel for the petition that issue the counter filed by 1TO23 is 1TO23 copy will be served.
copy already served.
Copy served.
Go to the government and respondent number 4.
କୋଉ ଦିନ ଫାଇଲ କଲେ ଡେଟ୍ ଟା କହିପାରିବେ?
Yes, 25/4. 27/4. 27/4 2026.
ठीक है. The learned additional standing counsel for 1TO23 OP1 TO23 as well as the learned counsel for the OP ଆପଣ 4 पाई सर
4 only.
for OP4 5 no 4 seek for the time to obtain instruction in response to the rejoinder. Stop. List in the matter shall be listed at the for admission. अच्छा mediation पे रही
No, Your Lordship. This is a service matter. Your Lordship.
अच्छा
It can be disposed of.
for admission in the week commencing 29/6/2026 that I would line add for you, though the matter is listed for under the heading for referral to the special mediation rate 2.0 mediation for the nation. It is submitted that the matter relates to service of petitioner. ଆପଣଙ୍କର କଣ ଚାକିରି ଚାଲି ଯାଇଛି?
I could not be engaged due to wrong selection.
Service of the petitioner who was applicant to be selected as intensive education volunteer
Yes.
for Chhatia dash Champapur, Ichhanagar, Patna primary school. So the petitioner inter challenges selection of OP5.
OP not 4.
OP4, sorry.
Which is now no more in service.
OP4. ठीक है. ना एटा को आफ्टर नोटिस रे आने पड़े. एटा हबनी मेडिएशन रे ही परिबनी. Accordingly, it is submitted by the learned counsel for the petitioner as well as the opposite parties that the matter should be listed for admission hearing. आप पढ़े लिखिए list for admission hearing. Yes, Mr. Das.
Grateful.
Item 2.
Mr. Ashok Das for the petitioner, opposite party. Yes.
May I please, no, senior. My lord, in this case, my lord, the petitioner challenging the order of maintenance.
Yes.
Husband. Order of maintenance, that is annexure 4, running page 34.
Yes.
Family judge, Ganjam.
Yes.
My lord, where he has awarded 3,000 to wife, 8,000 to wife, 3,000 daughter, and 2,500 hochi out of chua.
Yes.
My lord, that is challenging, my lord. And that is where excessive award has been passed so far as petition is concerned. And
How is it excessive, sir? Evidence?
evidence is daftari
ଦେଖାନ୍ତୁ
ଗୋଟେ
କଣ ଏଭିଡେନ୍ସ ଥିଲା ପ୍ଲିଡିଂସ୍ କଣ ଥିଲା ଦେଖାନ୍ତୁ
the pleading so far as the judgment is concerned. And
ଓକେ ଏନି ଅଦର ଗ୍ରାଉଣ୍ଡ ଏକ୍ସେସ୍ ଆଉ କଣ ଗ୍ରାଉଣ୍ଡ
excess ground, the so far evidence is concerned. And I have filed the evidence copy of 28, 29, 23 PW1.
ପ୍ଲିଡିଂସ୍ ଆଗ ଦେଖେଇବେ
Again.
ଗୋଟେ ଡିଭିଜନରେ
Award has been excess, my lord.
ପ୍ଲିଡିଂସ୍ ଆପଣ ଆୱାର୍ଡ ହାଜ୍ ବିନ୍ ଏକ୍ସେସ୍ 5 ଥର କୁହନ୍ତୁ
ଆଜ୍ଞା।
ନୋଟେଡ୍ ଦ୍ୟାଟ୍
Again.
ଆପଣ ପ୍ଲିଡିଂସ୍ ଦେଖାନ୍ତୁ କେତେ ଟଙ୍କା ଆପଣ କଣ ଷ୍ଟାଣ୍ଡିଂ ଆପଣଙ୍କ କଣ ଥିଲା ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ
Written statement. Annexure 2, your lordship's kindly have a glance, that is page 17.
କୋଉଠି ଲେଖିଲେ straight away come to the paragraph so that we can save time ଆପଣଙ୍କର 13 ଟା ଆପଣ ଏଗେନ୍ଷ୍ଟ ଦେଇଦେଲେ ଆପଣ ପୁରାଟା ଲୋନ ନେଇକି ପୁରାଟା ଧରନ୍ତୁ ଡେଟ୍ ସର୍ଭିସିଂ ରେ ପଳେଇବ ମିଷ୍ଟର ଦାସ
Again.
ଆପଣ କେତେ ଟଙ୍କା ପାଉଛନ୍ତି ତ ସେଟା ଏଭିଡେନ୍ସ କଣ ଦେଇଛନ୍ତି 19,000
Evidence ଲେଖିଛି 19,000 ପାଉଛନ୍ତି ଥିଲା claim କଣ
ଆପଣଙ୍କ
30,000.
ଗୋଟେ ପେ ସ୍ଲିପ୍ ଥିବ
Again.
ଡିଡ୍ ୟୁ ପ୍ରୁଭ୍ 19,000
ନା.
ଠିକ ଅଛି
My lord, you lord.
ତାପରେ ଆପଣଙ୍କର ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ଆପଣଙ୍କ ଯୋଉ ଡାଳରେ ବସିଛନ୍ତି ତାକୁ ୟୁ ହାଭ୍ ଚପ୍ଡ ଅଫ୍ ଦ୍ୟାଟ୍ ବ୍ରାଞ୍ଚ ୟୁ ହାଭ୍ ଟେକେନ୍ 4 lakh ଲୋନ୍
ଲୋନ ବାବଦକୁ
ଭଲେଣ୍ଟାରୀ ଡିଡକ୍ସନ୍ସ ଆର୍ ନଟ୍ ଟୁ ବି ଆକାଉଣ୍ଟେଡ୍ ଫର୍ ଆପଣ ଲୋନ୍ ନେଇକି ଆପଣ ଯାହା କରିବେ ଅୟସ କରିବେ ବିଲ୍ଡିଂ କରିବେ
ନାଇଁ
ସେ ଲୋନକୁ 2 ଲକ୍ଷ ଟଙ୍କା ଯଦି ୱାଇଫ୍ କୁ ଦେବେ ତାହେଲେ ଠିକ ଅଛି
ସେ ପିଲାମାନଙ୍କ ପାଇଁ ତ ଲୋନ ନିଆଯାଇଥିଲା ନା,
ସେଇଟା
subsequent-
ଦେଖେଇବେ ନା ସେଇଟା ପ୍ଲିଡିଂ ରେ ହିଁ ନାହିଁ
ଆଉ
ସାର୍ ଆପଣ ଯେତେବେଳେ ପ୍ରିପେୟାର ହେଲେ ରିଭିଜନ ଟା ପ୍ରିପେୟାର କଲେ ଏଗୁଡାକ ଦେଖିବାର ଥିଲା ଦିସ୍ କ୍ୱେଶ୍ଚନ୍ ୟୁ ସୁଡ୍ ଆସ୍କ ୟୁର କ୍ଲାଏଣ୍ଟ ଇନ୍ ଦ କ୍ଲାଏଣ୍ଟ ଇଣ୍ଟରଭ୍ୟୁ
ଆଜ୍ଞା।
କାରଣ ସେ ଯାହା କେସ୍ କରିଛନ୍ତି ଟ୍ରାଏଲ କୋର୍ଟରେ ତାକୁ ଇମ୍ପ୍ରୁଭ କରି ହବନି
ନାଇଁ
ତେଣୁ ସେଇଟାକୁ ଆଉ କଣ କରାଯିବ
ସେ
ଆଜି ସାରିଦବା ନା ଆଉ ଗୋଟେ ଦିନକୁ ଆସିବ
ନୋଟିସ ବି ଯାଇନି, ଏଟା ଫାର୍ଷ୍ଟ ଟାଇମ
କୋର୍ଟ ଯାଇପାରିବନି I have already delivered a judgment.
ୱିଦାଉଟ୍ ନୋଟିସ
Order 47, no, without notice because I have to see fast.
ଆଜ୍ଞା।
Order 41, there is one judgment, of course, of Supreme Court C. Lalita, but I have also dealt with Order 47, Rule 10.
ଆଜ୍ଞା।
Mandatory, it can be dismissed at the stage.
And that is your lordship correct, madam. So but notice
Lordship correct ମାନେ ଆପଣ correct ହବା ଦରକାର ମୁଁ correct ହେଲେ କଣ ମୁଁ ତ arguing counsel ନୁହଁ ନା
ଆପଣ up to date, ଆମ ତ up to date
ନାଇଁ,
ହୋଇପାରୁନି।
ସେମିତି ସାର୍ କୁହନ୍ତୁ so that cannot be excused, sir. I am to be educated by you. ଆପଣ ଯଦି ଏଇ କଥା କହିବେ ମୁଁ I am assisting you.
ଆଜ୍ଞା।
Up to date କଥା ନାହିଁ I have to
ଆମେ
assist.
ଆସିଷ୍ଟିଂ କରିବୁ ନା ସେପଟେ କେମିତି ହେବ?
କଣ କରାଯିବ କଣ କରାଯିବ
ତାହେଲେ ଆଉ ଗୋଟେ ଡେଟକୁ ଆସୁ ଆମେ ଦେଖିବା ମାଲଟ ଯଦି ନୋଟିସ
ସେଇଟା ଆପଣଙ୍କର ଫାର୍ଷ୍ଟ ଅଫ୍ ଅଲ୍ ଭଲେଣ୍ଟାରୀ ଡିଡକ୍ସନ ଟା କାଉଣ୍ଟ ହବନି ଇନଭଲେଣ୍ଟାରୀ ଟାକ୍ସେସନ କି ଧରନ୍ତୁ ଆପଣ ଗୋଟେ ଘର ହାଉସିଂ ଲୋନ ନେଲେ ଘରଟେ କଲେ ସେଥିରେ ରହୁଛନ୍ତି ଆପଣଙ୍କର ୱାଇଫ ପିଲେ ରହୁଛନ୍ତି ହବ that's a good it has happened in fact in division bench it was a plea in fact we have to consider that a court has to consider ଆପଣ ସେଟା ଲେଖି ନାହାନ୍ତି ଆପଣଙ୍କର ଫେରେ ଗୋଟେ ଆଜିକାଲି ଯୁଗରେ ଗୋଟେ ଲେଡି ଆଉ ତା ଦିଟା ଛୋଟ ଛୁଆ ସେ କେତେ ଟଙ୍କାରେ ଚଳିବେ ଆପଣଙ୍କର 19,000 ସେ କେତେ କହିଥିଲେ ଆପଣଙ୍କର ପିଟିସନରେ ତାଙ୍କ ୱାଇଫଙ୍କ ପିଟିସନରେ ଆପଣ କେତେ ସଜେଷ୍ଟ କରିଛନ୍ତି
ସେ ଆନେକ୍ସର 1 ରେ କ୍ଲେମ କରିଛନ୍ତି ମତେ 10,000 ତାକୁ ଦିଆଯାଉ 5,000
ଆପଣ ସାର୍ ସାଲେରୀଟା ଦପ୍ତରୀଟା ଧରନ୍ତୁ ହାଇକୋର୍ଟରେ ହାଇକୋର୍ଟର ଦପ୍ତରୀ ହଉଛି 67,000 ସ୍କେଲ
ସେତେବେଳେ 30,000 ଲାଇବ୍ରେରୀ ନା ମାଇଲଟ
ବର୍ତ୍ତମାନ 67,000 ସ୍କେଲ ଆପଣ ତ 19,000 ଯଦି ହେଇଛି ଷ୍ଟିଲ୍ ଚ୍ୟାଲେଞ୍ଜ କରିବେ କି କରିବେ ଅଲଗା କଥା ଆଇ ୱିଲ୍ ନଟ୍ ଇଣ୍ଟରଫିୟର ବଟ୍ ୟୁ ହାଭ୍ ଟୁ କାଉଣ୍ଟ ୟୁର ବ୍ଲେସିଂସ୍
ଆଜ୍ଞା।
ଯେ ଗୋଟେ କୋର୍ଟ ସେ କୋର୍ଟରେ ବି ଦପ୍ତରୀ ଅଛନ୍ତି ସେ ତାଙ୍କୁ 19,000 ହିସାବ କରିଦେଲେ
ଦୁଇ ପ୍ରକାର ଦପ୍ତର ପରମାନେଣ୍ଟ ଟେମ୍ପୋରାରୀ
କହିପାରିବେନି କଣ ହେଇଛି ସେଟା ମୁଁ ସେଇଥିପାଇଁ ପଚାରିଲି ଆଗ କ୍ୱେଶ୍ଚିନ୍ ୱାଜ ପର୍ଟିନେଣ୍ଟ ଆପଣ କଣ ଏଭିଡେନ୍ସ ଥିଲା ଆପଣଙ୍କ ସାଲାରୀ ସ୍ଲିପ୍ ନା କଣ ଇଏ had learned counsel for the petitioner. The petitioner husband in the marriage is before this court seeking revision of the judgment dated 11/10/2021 passed by the learned judge
Family is Hon'Ble.
ଆପଣଙ୍କର ଏଟା ଡିଲେ ନାହିଁ ନା କଣ ଲେଖା ହେଇଛି ମୁଁ ବୁଝିପାରୁନି ତାପରେ ରିପୋର୍ଟ କଣ ଲେଖା ହେଇଛି रिपोर्टिंग का ही डिले कौन कौन चालଛି काम बरे लिमिटेशन लिखा है डेट ऑफ जजमेंट ब्लैंक सब ब्लैंक छाड़ देले आ गोटे कोडी करछन ना कोन करना है नेक्स्ट again the petitioner husband is before this court seeking revision so and so. The staff report indicates that staff reporting regarding delay in presenting the revision has not been made. The matter shall be placed for staff reporting and listed for fresh admission. Day after tomorrow, ना day after तुम आज जीवो फिर पासिबो बुझी होची केते 11 14 कर दे तो है
ଆଜ୍ଞା
डिले नहीं कि मिस्टर दास
କାରଣ ମୁଁ ଫାଇଲ କରିଛି ଲର୍ଡସିପ ଯେ ଅର୍ଡର ଜଜମେଣ୍ଟ ପାସ୍ଡ ହେଲା
से देखो से
11 ଅକ୍ଟୋବର ଆମେ ଫାଇଲ କରିଛୁ ଦିସ୍ ପିଟିସନ ଫାଇଲ
ଜାନୁଆରୀ।
25 ଜାନୁଆରୀ
11 ରୁ କେତେ ଦିନ 90 ଦିନ ନା
90
60
90 within the time ମୋ ମତରେ within time
ଏ ସେଟା ତ ଲେଖିବେ ସେଟା ସେ
ଆଜ୍ଞା।
କିଛି ଲେଖିନା ଠିକ ଅଛି ଆପଣ ଯାଇ ହେଇକି ଆସୁ ବେଟର
ଆଜ୍ଞା
yes next କିଏ କହିଲେ ଆରେ ଷ୍ଟାଫ ରିପୋର୍ଟ ରିଟାୟାର କରିଗଲେ ଯେ ତାଙ୍କ ପାଖକୁ ନ ଦେଇକି ଆଉ କାହାକୁ ଦେବେ ଆପଣ ତ ଷ୍ଟାଫ ରିପୋର୍ଟ ମାନେ କଣ ରିଟାୟାର କଲେ ବୋଲି କରିବେନି କିଛି ଆପଣ ତାକୁ ଦେଖେଇବେ କଣ କରୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି କଣ ଚାଲିଛି
item 3
Sonali Panda for the petitioner yes
In this application, we have challenged the dismissal of the CLP execution regarding the area maintenance. In
କାହିଁକି ଏକ୍ସିକ୍ୟୁସନ ଡିସମିସ୍ ହେଇଗଲା ପ୍ରପର୍ଟି ଷ୍ଟେଟମେଣ୍ଟ ଦେଲେନି କି
no, execution ଟା ସେମାନେ dismiss କରିଦେଇଛନ୍ତି after passing the order in MATA number 126 of 2019.
ସେଥିରେ କଣ
ସେଥିରେ
ହେଇଥିଲା
permanent alimony ହେଇଗଲା 10 lakhs. ଆମେ ସେ CRP ରେ execution ରେ file କରିଥିଲୁ for area maintenance.
so just examine when the honorable the learned judge has granted you permanent alimony whether this factor has been considered or not. This is application under section 125
120.
125. So after Rajneesh versus Neha, Supreme Court has said all applications, that possibly four kinds of perhaps 125, 24, then one that maintenance, adoption and maintenance, there is a provision, section 20. Another is DV Act. So all have to be taken note of while deciding the quantum. And now, if it was during other aspect is that 125 during subsistence of marriage and after submarriage, after dissolution of marriage.
No, marriage was not this one.
Now
Now
execution file kale
execution ବେଳକୁ divorce ହେଇନଥିଲା ସେ MATA ରେ ହିଁ divorce allow ହେଲା
नहीं ताको प्ली थिला कि एग्जीक्यूटिंग कोर्ट रे satisfaction of the decree थिला कि
I will examine.
सेटा देखो होला Sonali Panda for the petitioner. The petitioner wife before this court seeks revision of the co-order. Who page ରେ ଅଛି?
Order, page 9,
Date that.
12/5/2023.
The order dated 12/5/2023
In CRP execution number
in
12.
CR dot capital P dot into bracket EXP bracket closed case number 12 of 2022. Whereby the allotted Just Family Court has dismissed the execution or dropped the execution,
Dismissed.
dismissed the execution in view of the order passed by in MATA number 126 of 2019. Ms. Panda, obviously, otherwise the family court, how the Just Family Court doesn't have jurisdiction. 125 is a magistrate. So it was before him. For MFSA, this 125 was considered by him, then he has closed it. What like that? In the MATA number 126 of 2019, filed by the husband in the marriage, the present petitioner being the opposite party. Granting permanent alimony at rupees 10 lakhs.
Yes.
10 lakhs. Stop. The Learned Council, the Learned Council has adjournment to examine the consequence of grant of permanent alimony and whether the amount directed under section 125 CRPC was subsumed oblique adjusted in the said amount. Stop. କେବେ ଆସିଲେ ହବ?
Before vacation.
Before vacation ଦରକାର। ଏଥିରେ କଣ ଅଛି ଆପଣ ଆଲିମୋନିଟା ପାଇଲେନି ନା ନାଇଁ?
ହଁ।
ହେଲେ ବ୍ୟସ୍ତ ଠିକ ଅଛି ରଖନ୍ତୁ but you have to
Ba-
get clear instruction. You have to tell your client that both multiplicity of these proceedings is not possible now. List for fresh admission in the week commencing?
18/5
ନାଇଁ ସେ 18/5 ରେ ଆପଣ କେତେ ଦେଢ଼
15
ହଁ 15ଟା ପରେ ଆପଣ ଆଡ୍ କରିବେ ଯଦି ଜଷ୍ଟ ସେ ଉପରେ ଆପଣ ଖାଲି ପଢିବନି କିନ୍ତୁ ଆପଣ ଖାଲି ଆଡ୍ କରୁଛନ୍ତି ୱିକ୍ କମେନ୍ସିଂ 29/6
Yes, ma'am.
29/6 ଆସୁ ଟେକ୍ ଦ୍ୟାଟ୍ ଇନଷ୍ଟ୍ରକ୍ସନ
Yes, ma'am.
ଆଉ ଯଦି ଗୋଟେ କ୍ଲିୟର ପିରିୟଡ ଥିବ ଆପଣ ସେଟା you should have pleaded there before the trial court
Yes, ma'am.
and you check the pleadings in the execution also. He might have taken that plea that it has been satisfied because already the matter has been disposed of in MATA granting permanent alimony. Yes.
Item 4,
Mr. Jena टे मेसेज कले से कौन आम कथा शुणी पारिबे? Yes, Mr. Jena. नहीं तांको मैटर नु एटा से तांकर 48 एटा आउ जणे की ठीक अछि 4 पास ओवर करते तांकर जदी हेतो देखिबा ठीक अछि पास
item
ओवर
5,
भाई परसोक बेहरा तो करना से मेंशन करूतिले महांती कोडे गल पास ओवर
item 7,
you are Mr. Misra.
Yes,
Mr. Sangram Misra for the petitioner.
PK Misra.
Mr. PK Misra for the petitioner. Yes, please.
This petition is transfer of case from OPID to Special Court CB. In this case, 2 cases were pending before SDJM Jasper. As per the order
But
of
kindly check the order dated 7/4/2026. Read that.
yes, ma'am.
Place it 7/4. Just hard.
Yes,
Read it.
yes, 30 million.
Para 2 ରୁ ପଢ order ପାଉଛନ୍ତି paper ଲେଖା ୟୁଜ କରୁନାହାନ୍ତି this is for you only ଦେଖି ଦିଅନ୍ତୁ
It is
The following has been said in the writ application. देखिले.
that your lordship may cease to admit this transfer petition.
Okay, you can leave the prayer. Prayer you can leave. Okay.
Yes.
Then read para 3.
Paragraph. Learned counsel for the petitioner relies on the judgment of the Honorable Court in Subrat Chattaraj versus Union of India, 2014 SCC. The copy of the judgment of the Honorable Supreme Court annexed to the writ petition, learned counsel for the petitioner refers to paragraph 34 and 35, which are produced herein.
Reproduced, not produced, reproduced.
We produce
Good.
here. In the circumvention, we are inclined to allow all this petition and directed transfer of the following cases registered in different police stations in the state of West Bengal and Odisha from the state police agency to the Central Bureau of Investigation.
Good.
Then state of Odisha. All cases registered against the 44 companies mentioned in our order dated 36/3/2014, passed in Subhadra Chattaraj, Union of India. CBI is also permitted to conduct further investigation in all the cases in which charge sheet have already been filed. We reserve liberty for the Joint Director CBI in charge of the states of West Bengal and Odisha to seek further direction in relation to transfer of any other cases or cases that may require to be transferred for investigation to the CBI for a full and efficient investigation in the scan.
Read para 4 पढ़ो. Don't stop. जल्दी करो तो.
Land counsel for the petitioner as well as land state counsel are apprised of the paragraph 36 of the judgment of the Honorable Supreme Court, which are reproduced herein from SCC online. Transfer of investigation 44 to Central Bureau of Investigation in terms of this order shall not, however, affect the proceeding pending before the Commission of Inquiry established by the state government, or shall any action that is legally permissible for recovery of the amount for payment to the depositor. Needless to say that the state police agency is currently investigating the cases.
para 5 पढ़ो.
In view of the direction of the Honorable Supreme Court, that the order shall not, however, affect proceeding or shall any
और stall ठीक रे पढ़ो सब आपण भूलभाल पढुछन मु बुझि पड़ले.
stall any
Action.
acting that is legally permissible for recovery of the amount for payment to the depositor. Land counsel for the petitioner shall apprise this court whether the pending OPID cases which is initiated for recovery of the amount can be transferred to be taken up by special judge. Land counsel for the petitioner has adjournment. The matter shall be listed on.
So what you are seeking, it is contrary to Supreme Court direction.
Miller, my humble submission.
Humble I am also humbly requesting you to go through the order. Let us not spend time in this.
Yes, Miller.
We are doing the matter.
I have to clarify something from para 36. Transfer of investigation to the Central Bureau of Investigation.
ଆପଣ OPID ଚାହୁଛନ୍ତି ଫେରେ 36 ଦେଖୁଛନ୍ତି. ଆପଣ ଚାହୁଛନ୍ତି ଏ କେସ୍ ରେ OPID ରେ ଟ୍ରାନ୍ସଫର ହେବା ପାଇଁ.
Miller, pending ଏଥିରେ ଯୋଉଟା mention ହେଇଛି, my submission is that ଯୋଉଟା inquiry commission ଯଦି establish ହେଇଥାନ୍ତା.
ଆପଣ ପଢୁନାହାନ୍ତି, that's the problem. Inquiry କଥା ଲେଖା ହେଇନି. पारा आपण जोटा सुप्रीम कोर्ट डायरेक्शन टाकू आपण जोटा इंटरप्रेट करछन आपण गोटे पर्सन छाड़ देले पूरा और लिखा हिची आपण इंक्वायरी को देखछन और अंडरलाइन पोर्शन ना देखंतु
यस
और स्टॉल एनी एक्शन
और स्टॉल एनी एक्शन माय सबमिशन इज
ताको ऐड करन सेटा सुप्रीम कोर्ट रे कहिबे ना एठी मते कोन कहउछन
एक्शन ता जदी सेते टू केसेस वर पेंडिंग बिफोर एसडीजेएम जाजपुर. That was investigated in that was tried in
आगे OPDR फिर आपण अगेन आपण केते तोर बुझेबी आपण लेट अस कंसिडर आपण OPDR केस ट्रांसफर चाहउछन ना नहीं.
yes
yes So OPDR case jota, that is for recovery or not?
Yes, recovery for recovery, but that was not pending before that OPID. Subsequently, it was transferred to OPID.
Subsequent or earlier is
At
not
that
the
time,
point.
well,
How do you implement the order passed by the Honorable Supreme Court, which
Yes,
says
please.
very clear, stall any action that is legally permissible for recovery of the
Yes.
amount for payment to the depositors.
I am
Interestingly, the Supreme Court uses the word legally permissible. So it
Yes.
takes care of proceedings which are pending or otherwise. Pushpachandi.
no, I am going to that stage also. My humble submission, Milord.
Hey, humble submission karantuni, when you are interpreting Supreme Court's judgment,
Yes.
you can't reread or add words. I
No,
cannot.
I am not adding word,
So again read that line.
but in I am
Says or stall any action that is legally permissible.
stall any action.
Ah.
If that was pending in investigated and pending in OPID court at that time when one case was transferred from
ଆପଣ one case ରେ କହିନାହାନ୍ତି ଶୁଣନ୍ତୁ ଗୋଟେ ଭୁଲ ଥରେ ହେଲା ବୋଲି one case କେମିତି କିଏ transfer କଲା? Who transferred?
CBI has been taken up that case from SDJ.
କରିବେ ତାହେଲେ I cannot violate Supreme Court order because CBI has done
It is
something.
not violation. When
No.
my submission is when pending cases.
ଆପଣଙ୍କ ଶୁଣନ୍ତୁ କୋଉଠି ପେଣ୍ଡିଂ କେସ୍ ଲେଖା ହେଇଛି ଆପଣ ସେ ୱାର୍ଡଟା ସେଟା ପଚାରି ପଢୁନାହାନ୍ତି
No.
ଆପଣ ଆଡ୍ କରୁଛନ୍ତି
From it legal construction, it is well observed that
ଆପଣ ଠିକରେ ପଢୁନାହାନ୍ତି କି ଥଙ୍ଗେ ଥଙ୍ଗେ ପଢୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି ଆପଣ ସେ
State
ଯୋଉ
government-
stall any action
or
What
stall
pending like
any action,
Huh.
any action.
rather pending
Action that was taken up at that time.
ଲେଖା ହେଇନି
Right.
ସେଟା ଆଜ୍ଞା
No, should be construed in that
No, no.
light.
I am not here to construe Supreme Court judgments. I cannot. To your convenience or my convenience.
No, my
ଆପଣ ଫେରେ ସେଠି ଫେରେ ଦି ଚାରିଟା ୱାର୍ଡ ଆଡ୍ କରୁଛନ୍ତି
no state
ଆପଣ
government.
ଶୁଣନ୍ତୁ how you are reading now I am reading for you. Stall any action that is pending ଆପଣ add କରିଦେଲେ Supreme Court ଲେଖିଲେ legally permissible
Permissible.
for recovery. So interestingly Supreme Court says legally permissible ଆପଣ କହୁଛନ୍ତି pending.
No,
So I have to reject that.
no, permissible for recovery of the
Yes,
amount for
yes,
payment.
Supreme Court says any
have
action legally
deposit.
permissible. You are adding the word for pending.
No, at that time,
It
it was not.
କହୁଛନ୍ତି pending ତାପରେ କହୁଛନ୍ତି no.
At that time, it was not recovered from the company to deposit for the.
Sir, go by being a lawyer, you must assist properly or
Yes,
read properly.
yes, no. Sorry.
You go by the records. You are seeking transfer of, you have read the paragraph prayer, OPDR
Yes.
proceeding.
Yes.
OPDR proceeding, Supreme Court says that it has to continue. Now, CBI likes to take it over or some court has directed, I cannot say.
Continue in that sense, if it was before that court
It has to
at
be
that
rejected.
time.
It has to be rejected. I have to record. It is submitted by the learned counsel, Mr. P.K. Misra. He submitted hard learned counsel for Mr. P.K. Misra for the petitioner. He, with reference to the earlier order dated 7/4/2026 regarding the directions of the Honorable Apex Court, as reproduced in paragraph 3 of the said order, as well as paragraph 44 of the directions of the Honorable Supreme Court in Subrata. Subrata Chattoraj versus Union of India 2014-8 768. It is submitted that the directions of the Honorable Supreme Court, that is court, stall any action that is legally permissible for recovery of the amount for payment to the depositors. Already, para 5. Then quote ends. Shall be read as pending actions, pending proceedings. In considered opinion of this court, when the Supreme Court has made it clear and not mentioned the word pending, this court cannot add those words to the directions of the Honorable Supreme Court in paragraph 44. OPDR case ta kodina initiate ala
Yes, Miller. City number 9/17.
କୋଉ ଦିନ ଫାଇଲ ହେଲା? OPDR ଟା
2017.
2017. FIR ଟା
FIR টা before 2013.
13. Apparently, the FIR, the OPDR case arises out of a FIR dated 16/6/2013, which would also amount to a pending action if by accepting the submissions of the learned counsel for the petitioner. Yes, anything else or disposed of?
No, my
CBI is not a binding precedent for the High Court. You must understand. Suppose somebody has done a mistake.
some CBI also filed some transfer petition to take up the case in that light from OPID courts.
Sir, it is darkness. It is not light. Wow, you are darkening those lines. When Supreme Court does not say that, Supreme Court says that shall not stall any action that is legally permissible for recovery.
Yes,
ଆପଣ ସେଟାକୁ କରିଦେଲେ ଯେ all pending action, all action should be ତାପରେ OPDR ଯୋଉ OPID it is transferred to CBI court, taken up as OPID court, or what proceeding ଟା କଣ ରହୁଛି?
proceeding for recovery and penal
Correct.
provision is
So
there.
transfer ହେଲା ପରେ କଣ ହବ?
ସେ conviction ହେଇଛି conviction ହବ କି ତାର
recovery କଥା ପଚାରୁ।
recovery ପାଇଁ ବି case CBI ଯୋଉ
Other than OPID କଣ pending ଅଛି କି? You must understand the question.
ହଁ pending ଅଛି
କଣ proceeding ଅଛି recovery? କୋଉ provision? Provision ଟା କହିବେ। Your first duty as a lawyer is to be particular.
as per order of that court when I have plead
As per order of
guilty,
that court, no.
guilty I have
Recovery proceeding ଟା କଣ? What is that proceeding? Like it is a execution. It is a କଣ proceeding pending ଅଛି? Like OPID is a recovery proceeding.
no proceedings.
And property attachment ହଉନି?
Yes,
କାଇଁ attachment ହଉଛି? Punishment.
his property, his company property
OPID
has
ରେ ଯୋଉ
been
attachment property କଣ ପାଇଁ ହୁଏ?
other
They are auctioned and so the whatever consideration is received that
all
is
the
distributed among the
Miller.
I mean debtors, creditors.
All the properties of the different companies of that petitioner has already been attached by CBI.
ଏଟା କଥା ଅଲଗା କଥା ଆପଣ ଗୋଟେ କଥା କହିଲେ ଆଉ ଗୋଟେ କଥା କହୁଛନ୍ତି। I am asking you whether the
No,
proceeding
no.
pending is a recovery proceeding
No
or not.
other than OPID in that particular case, no other proceeding.
Then you are distorting Supreme Court's order, which I cannot do.
Distorting. My humble
Obviously,
submission is-
you are adding those words pending all these things, and it is a even if your argument fails because it is a 2013 case.
13 case.
When the case starts,
OPID has not been found at that time.
whatever.
And next
In any
hearing,
event,
judgment
this
and
court cannot add words to the directions of the Honorable Apex Court, which is very clear.
next date,
They can't be interpreted further
next date, my lord.
as is sought to be.
Decision rely.
Stop. Now the petitioner seeks and has adjournment. The matter shall be listed for fresh admission in the week commencing 29/6/2026.
Public.
Item A.
Niranjan Panda for the
Please,
petition.
my lord, here, my lord also heard this matter at length. Only my prayer is to transfer that the case from the Umarkot to that is Bhavanipadna.
So kindly read sir, order dated 24/2/24.
Sir. 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 এটা তো
ସେଇଠି ଆପଣ ଏଇଟା ୟୁଜ କରୁନାହାନ୍ତି
স্যার
ଯୋଉ ପେପରଲେସ୍ ଟା ଅଛି ସେଟା ୟୁଜ
ଆଜ୍ଞା 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 স্যার এটা তো। হ্যাঁ। 24 থেকে। Okay. Sir, petitioner by filing the application seek to transfer the air case number so and so corresponding to the Dabunga PS station so and so pending before the Lawrence JMFC Umar Court to Lawrence JMFC Dharmagad under section 407 of CRPC since repealed and substituted by the paramateria provision contained in BNS 2023. It is fairly submitted by the Lawrence Council for the petition that as per the allegations and the FIR, the occurrence was also at Dabunga and accordingly the matter is pending with the court at Umar Court. It is submitted that the petitioner's residence is at about 100 kilometers at Dharmagad, for which he is facing the difficulty if considered in consider opinion of this court whether the place of residence of the accused can be the factor for transferring a trial became an issue to be delved into in the present case. An additional government advocate submitted that earlier the petitioner has approached this court in CRMC 3728 of 2025 in the said proceeding. The coordinate bench by order dated 10/12/2025 has been pleased to direct the proceeding pending before the Lawrence JMFC Umar Court to be disposed of as expeditiously as possible. It is submitted that after a direction is issued by this court for expeditious disposal, each prayer for transferring the matter is allowed. That would be in conflict with the earlier direction which was issued as paid for by the conflict for the section of higher. Adjourn the address to the said aspect of the matter shall be listed in so and so from 2023-2026, sir. Sir.
So thereafter it has been adjourned for
Yes.
2 occasions.
It was, we do oblige that the order.
So now you have to tell that the place of residence of the accused and when there is an order by the coordinate bench to expedite the trial, whether I can exercise
Yes,
the jurisdiction.
for the order passed by the honorable
Place of residence of accused को provision रे अछि जे transfer हबो बोली.
No, because for speedy trial as well as the convenience of the
Speedy trial
accused.
already order I cannot सेटा आपण सुप्रीम कोर्ट रे चैलेंज करे पड़ियो. Speedy trial रे थरे गोटे coordinate bench देला परे
That
I
has,
cannot reopen.
sir, that has not yet been complied with. I do understand. Suppose
Sir,
the order,
whether sir, please सुनନ୍ତୁ आपण जोडा कहउछन्ती.
Yeah.
If it is not complied, I will again pass order. No. You can file another application before the same.
May I request sir one thing?
So,
Sir, may I
नहीं
request?
आपण submit करନ୍ତୁ. एथे request ले personal. बाहर लिखाले request करिवे.
That is my
legal submission.
submission. That is my submission. It could be better, I think, if the matter to be transferred to the coordinate.
No, better नहीं. I cannot. सेटा से जो notification दा change ही जाइछ. ଆପଣଙ୍କର it has to be listed before I have determination. I cannot send it to another bench. First of all, I don't have a power to transfer.
Only one thing that I am not inclined to hear this matter.
No,
Matter to
I cannot do that. I cannot. Someday, up to my liking, I will
Yes.
adjust the determination. No. Once it is an assigned matter, unless I am otherwise, I have some, conflict of interest. तम तो से जानी ची तांकु. कि आपण मो रिलेशन सेटा अलगा कथा सेठी नले मु हाउ कैन इट
now the difficulties are arises because there are
it is not maintainable.
One thing, suppose there is an order passed by one coordinate bench and it is also go against the any order passed by my lord, that is there.
Sir, सेटा आपण problem होची जे आपण सेटा disposed of matter गोटे अलगा जिंसो.
That is for pitching
आपण TRP CRL फाइल कले.
Again,
TRP CRL is my determination. I have to take it up.
So my prayer is to transfer the matter from Umar Court to
That has to be rejected. The prayer on the basis of because you stay at some place.
That is my residence. Now I am.
So wherever
when I was serving
kindly look at it is already noted, sir.
Sir.
Para 2 and 3. It's already noted, sir.
It is fairly submitted by the Lawrence Council for the petition that as per the allegations and the FIR, the occurrence was at Dabunga and accordingly the matter is pending before the court at Umar Court. It is submitted that the petitioner's residence is at about 100 kilometers 100 kilometers at Dharmagad, for which he is facing difficulties. Can a person in a rocky area cover the 100 kilometers?
Sir, if he is accused, he has to. Sir, the CRPC provision, I cannot invent it.
Accused man, he is a man. He is
Sir,
not.
man or
Unless and until
man-
he, or sir, unless and until.
नहीं नहीं सीधा नहीं है.
ठीक है सर ठीक है सुनो तो ठीक है.
I'll record it, sir.
ठीक है. Unless and until a person is also declared accused or convicted by a competent court, he cannot be treated as an accused. My lord knows better.
अरे ना भूल कହୁଛନ୍ତି.
What are we doing?
अरे प्रिजम्पशन ऑफ इनोसेंस अछि सेपे तो अक्यूज कुआ जाउछ नोट तो कन्विक्ट कुआ जीवो.
Accused kuaje, but now he is not an accused unless and until
Sir, see, trial case
competent court also declared as an accused.
सेटा कन्विक्ट सेटा कन्विक्शन
Sir,
आपण
out of sir 100 convict, that 90% are accused by the court, sir.
मु तो कन्विक्ट कहिनी मु अक्यूज कहली दैट द बेस्ट वर्ड आई हैव यू.
Sir.
योर क्लाइंट इज एन अक्यूज्ड इन ही इज फेसिंग ट्रायल.
Sir.
आपण अंडर ट्रायल कहबे अक्यूज कहबे सेति
But
so his choice cannot be the place.
suppose my lord to dismiss the matter and again will pass an order by targeting the matter for expeditious disposal. What purpose will be? Because
No,
what
I
coordinate?
cannot. So that I
That is the
already-
obvious order, sir. That is the obvious order.
That I have considered. That prayer after it is passed by the
Coordinate, yes.
which I am not the superior court. You
Yes.
must understand.
Yes,
That order is by me only.
Sir.
You must understand. So I
Sir.
cannot improve that.
sir.
So disposed of. Okay.
Again.
Yes. Yes. Next.
Item 10.
Soumya Mishra for the petitioner.
It's here I've sought for the transfer of the divorce proceeding, which is initiated by the husband in the learned court of learned judge family court to Bhubaneswar to learned judge family court Dhenkanar, because the petitioner, who is the wife, she's staying in Dhenkanar. She's a loco pilot, and also Lordship knows that in the railways.
She is working as a loco pilot.
Yes. So she seeks for a transfer because due to her the nature of the employment, it may be difficult for her to transit to Bhubaneswar up and down. And she's also residing with her agent.
The proceeding before the learned judge family court Bhubaneswar is section 9 or 13.
Section 13. Section 13 petition.
So, did you ask that her that she wants to continue the matrimony or she wants divorce?
She does not want to continue.
She wants divorce.
She does not want to participate in the proceeding for a divorce. She does not want divorce.
She doesn't want divorce.
Does not want divorce.
She wants to register.
Continually. And in fact, this
because
proceeding.
if she wants and the husband wants, then both of them can file 13B.
Yes, ma'am. Yes. I also, in fact, have inquired.
But if she wants to register a prayer for
Yes.
divorce, grant of divorce.
In fact, I was talking to her and she's very shocked to receive the summons of the divorce proceeding also. Because there is no as such difficulty in the matrimonial family methods.
The husband is also employed.
Yes.
He works, sir?
He's an academician in the Einstein Institute, Bhubaneswar Pakir Juda, sir. Einstein College.
Try for reconciliation.
Yes, Phillips. That is my.
Because maybe the nature of job of the lady.
Yes, that is creating the difficulty.
That is she can't give time actually. It's a demanding job.
Mine. I was also trying to understand the schedule. It is very, very demanding. It's also a very young marriage in the sense that it was only solemnized on 29th of November 2023. So it's a very
Both
short
of them
period.
are young.
Yes, 33 and 34 respectively. So I believe, I hope
And
that
she was already working or she got the job after she got married?
she was working.
Even the husband knew that she's working
Yes,
as a
yes.
loco pilot.
Yes, well, your lordship has caught the crux. It is in fact that distance and the nature of the job which has created a little misunderstanding. But I believe and hope that this will can be reconciled.
Children are there.
Children are not there. Father is no more. So the ailing mother is with the wife, and her husband is working in Mumbai, and he is unfortunately also going through a matrimonial discount.
Basically. The wife in the marriage is the petitioner before this court is seeking transfer of CP number 228 of 2026 pending before the learned judge family court dash Roman 2, Bhubaneswar, Khordha. The CP has been initiated by the husband in the marriage under section 13 of the Hindu Marriage Act or Special Marriage Act.
The Special
27.
Marriage Act means special.
Under section 27 into
Yes.
bracket 1 into bracket small b and small d of Special Marriage Act 1954. Seeking dissolution of marriage solemnized between the parties on 29/11/2023 and grant of decree of divorce. So, it is submitted by the learned counsel for the petitioner that the wife petitioner herein wants to continue the matrimony. She has a demanding job working as a loco pilot in the Indian Railways, now under East Coast Railway.
Yes, ma'am.
Now under East Coast Railway. Posted at Deccanar.
Yes.
Posted at Deccanar. It is further submitted that efforts are made for the resolution of differences between the parties and arriving at a solution. Stop. Para, it is further submitted that the petitioner being posted at Deccanal finds it difficult to attend the case and she has to travel a lot because of the nature of her job. Now, issue notice to the opposite party along with this order. Stop, Para. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. Returnable date be fixed to returnable date be fixed to 29/6/2026. The matter shall be listed for orders in the week commencing. The week commencing 6/7/2026. Then idea 146 of 2026. Hard noted counsel for the petitioner. He reiterates his submissions as noted above. Issue notices as above, accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing would be as directed above. Stop. Para, in the interim, it is direct. Next date, do you know the next date?
Because today was one of the dates.
Okay.
Next date was not.
The pending CP, so and so, before so and so, shall be adjourned to a date beyond 13/7/2026, as would be convenient to the learned court in season of the matter.
Ma'am.
Yes.
Urgent copy.
Urgent certified copy as per rules.
Well, it's only one thing is assistant loco pilot.
Yes, senior assistant loco
Yes,
pilot.
yes.
Senior assistant.
Senior assistant.
But loco pilot I used as a generic kind of
Fine.
thing. Senior assistant.
Just wanted to
loco
bring that to your lordship.
Yes.
Obliged.
Senior assistant loco pilot.
Item 12.
No, I thought that he is working in railways.
Well,
So maybe that then he will understand the demanding nature of a loco pilot. Yes.
My lord, instruction. In this case, I have the instruction to file counter. So 4 weeks time may be allowed.
Apanko na sir?
Smriti Ranjan Parida.
Mr. S.R. Parida for the petitioner, Mr. Prem Kumar Mahanti, additional standing counsel for the opposite parties. The learned counsel for the petitioner refers to the order dated 10/3/2026 and submits that state is to provide instructions. Stop. Para. The learned AC submits that he has received instructions and file counter on behalf of the opposite parties. And 6 for the how much time, sir?
4 weeks.
6 for the 4 weeks time. Stop. Accordingly, the matter shall be listed for admission in the week commencing. 20/7/2026. The counter affidavit we filed upon serving copy thereof on the learned counsel for the petitioner by 29/6/2026.
Right.
By 29/6/2026. The petitioner shall have the liberty to file rejoinder if so advised in response to the counter. Yes. Yes.
Item 14.
14.
My lord, I am in BC, my lord. Item 13, my lord.
Yes, Mr. Nigam. Your other matter was adjourned. 13 was adjourned. Okay. You have instructions to appear in this.
No, my lord. I am the petitioner in this case, my lord.
He is referring to
13 ଆପଣଙ୍କର ପରେ adjourn କଲେ ନା କଣ? ହଁ ଆପଣଙ୍କର matter adjourn କରିଦେଲେ.
13, my lord.
ହଁ. ଆପଣ କଣ ବହୁତ କେସ୍ ଆପଣ ତାଙ୍କୁ କହୁନାହାନ୍ତି କରିବେ ଜୁନିୟର ମାନଙ୍କୁ ସେ adjourn କରୁଛନ୍ତି ଆପଣ କଣ କଲେଣି? କଣ କରିବେ ନା adjourn ହବ?
No, maybe adjourn, my lord.
କେବେ କୁ date ହେଇଛି?
We come in 6/7.
6/7.
Yes, my lord.
Mr. 14 ତାହେଲେ I already ହେଇଯାଇଛି. 14 Mr. Soumya Mishra for the petitioner. Yes.
But here the petitioner is the wife arising out of a proceeding under the section 13(1)(a) and 1(b) of the Hindu Marriage Act.
Yes.
A petition was not filed by the wife.
Yes.
It's stating that the petition for dissolution of divorce having been filed prior to the completion of 2 years as mandated by the statute is not maintainable. Now, there are 2 paragraphs in the petition itself which mention the date of desertion to be within that period. But the learned Judge Miller, Family Court Cuttack, in fact, passes an order saying that this cannot be gone into at the stage of at this stage. That is the subject matter of choice. Your Lordship sees the impugn order once. I've annexed it to the petition, Miller. It's a very short order. Page 60, annexure 4.
Yes.
Now, Miller, it's page 61 is the impugn operative portion of the impugn order. There they say that the petitioner has mentioned in para number 17 of the petition that the respondent has deserted him.
Just you can go through the entire order.
Yes.
The learned counsel for the
respondent. Yes. The learned counsel for the respondent is present. The record is put up today for filing of objection by the petitioner to the petition under Order 7, Rule 11 CPC, but no objection is filed by the petitioner. Though the
Order 7, Rule 11 for rejection of plaint.
Okay. That in all fairness will not be applicable to the proceeding because it's not a suit.
Yes.
But principal millets can be. Though the said petition is filed by the respondent on 4/7/25, so there is no necessity to adjourn the case record for filing of objection to the said petition. Third, learned counsel for the respondent submitted that there is no cause of action to file the present proceeding against the respondent. It is also submitted by the learned counsel for the respondent that the present case is barred by law in consonance with the ingredients of provision of section 13(1)(1)(b) of Hindu Marriage Act. Peruse the petition by the petitioner. It is noticed that the petitioner has disclosed the cause of action in paragraph number 16 of his petition. The petitioner has mentioned in para number 17 of the petition that the respondent has deserted him since 2019. But the above issue of the case can be adjudicated after the evidence adduced by both the parties. The disputed questions cannot be decided at the time of considering the application under Order 7, Rule 11 CPC. So the present petition has no merit and rejected put upon. Now, if your Lordship also sees the...
What you fairly say, Mr. Mishra, you are conscious that the court was considering Order 7, Rule 11.
Yes.
In that context, it has observed.
Yes. Only the petition can be gone.
If the factum of desertion in 2019 has to be gone into by the court.
Yes, my lord. Only humble submission would be if your Lordship sees the petition once, we'll just refer to that particular paragraph that the learned court below has referred.
Page?
Let's, the learned court below has referred to, if your lordship kindly sees page number 30.
30.
Yes, my lord. Para 16, if your lordship sees.
Yes.
That the cause of action for the petition arose on 24/7/2024 when the marriage of the petitioner with the respondent was performed by Hindu rites and
So
customs.
24/7/2024 is a mistake or 19 is a mistake?
So, my humble submission is that 2019 has been inserted only for the purposes of bringing this petition within the mandate. But in fact, his cause of action arose as per his own case on 24/7/24.
How the trial court could miss it?
Exactly, my lords.
No, actually,
because once, my lord, he has mentioned.
Kindly take para 18.
18, yes, my lord. Yes, my lord. But 18, he says the marriage solemnized between the parties on 1/5/2015. So marriage
I
date.
think 24 is a mistake.
No, it's in fact also.
So if you read 16, 17, 18 together.
Yes, my lord. There's another paragraph also.
Maybe the Learned Judge Family Court has missed it.
If your lordship only sees
Because
para 11.
he mentions 19, 24.
Well,
but I think 18 is the date 1/5/2015.
But that is the date of solemnization.
Yes. So desertion is 19, 4 years.
The desertion, he says, if your lordship also sees para 11 once, my lord, page 28. Let's say if para 11 was not there, I would have,
I think, sir, this is a gross mistake because they are retyping the copy in another petition.
Well,
the dates are really jumbled up.
That no amendment has been sought by. And here also, my lord.
No, the problem is, suppose now even I issue notice. They appear that and show that already you have mentioned 2015. So 24 is a mistake.
Man.
So this would have been pointed to the Learned Trial Court actually.
No, but it's 2015. That is there, my lord. That definitely. If your lordship sees 11 also, they're also the same date. Same date.
Actually, para 1 it is 15. Para 1 it is 15.
Sir, the date of marriage there's no dispute. But the date on which the petitioner, the husband says that he was deserted, Seta sir is 24.
19 kouchandi.
19, my lord.
1/2/1/5/2015.
Yes, solemnized on 1/5/2015.
So 19 is beyond 2 years. Then the initiation of the suit is the CP. Initiation of the CP is 2024.
24. What my humble submission would be that the petition read in toto points out to a clear date of cause of action. That is 2024. Now, in certain cases,
so it also points out shows 19.
19. But here, it's only
because after because the case is after she deserted in 19. 24 she lodged an FIR. In that sense, they are saying that after she has filed FIR, so I have filed a CP. Seeking dissolution.
The only there's a judgment of the Honorable Supreme Court.
Because these things cannot be. In fact, I cannot also take into this in the sense I can't have a trial kind of situation.
Absolutely not. So your lordship is to only see the petition filed by the husband for the purposes to see.
So at 5 places rather, 4 places. He mentions it as the date of marriage is 15. At 2 places it is 2019. And in another 3 places it is 24.
That's only
so it's a mistake, I think.
That's 2019 is only one place. That is para 17, which the learned court below has referred to. Solemnization date, my lord, is not a dispute. That is admitted. But here, my lords, if they themselves say that the cause of action arose for the petition, because 2 places it is mentioned as the same date, 24/7/2024. Same date, 2 places wherein the allegation of desertion has been mentioned, which is why, my lords, I filed the petition. Otherwise, my lord, I would not.
No, 16 is a clear mistake because 16 somehow is completely. If you read 1, 2, and 16, suddenly they say that cause of action for the petition arose on 24/7/24 when the marriage of the petitioner with the respondent was performed. It has been procured from some copy paste from some other petition.
Para 11, my lords, your lordship will see para 11, the same date, because even para 16, they say, but the opposite party intentionally and deliberately neglecting to the petitioner and his family members by honor and situation. So it points out to the date on which the neglect started and the desertion happened. Also,
the desertion is 19. Decision, as you have said, that
It's para 11 millets, it is clear admission millets on the part of the.
So now, so what was your order 6, even if not maintainable or otherwise?
Mine.
Kindly show the petition in order 6 rule 17.
No, but what my humble intention was in filing the petition also. Let's hear the, if your lordship sees the cost deadline, sees the age of the parties. Well,
Yeah.
If they can be, if they're before your lordships, well, it's I'm.
So the problem is that we are not having that facility of family court counselor.
Right.
We are appointing them as per rules. High Court is appointing them, but they are to be, because statutory counseling is as per the Family Courts Act.
Right.
So that facility should avail at the family court itself.
That is them. Because here
we are sending them for mediation.
Right.
Counseling is a concept statutory and it is mandated by the statute.
Very different than mediation.
Much different. Much different.
Because there's no persuasion, nothing.
And actually, the statute does not say regarding mediation. In MATA, where that is how we are doing mediation, even MATA also we do not have counseling.
And mediation also, your lordship is asking the consent of both parties to send it to mediation.
Correct. And counseling is a different concept altogether.
Absolutely.
So you avail that. So in case you file any petition or you have a difficulty, the court is not taking up conciliation, that's another thing. I mean, that's a separate thing. But here I think the court has also missed it because 3 places it is mentioned as 24. 3 places it is as a date of cause of. I think that sentence is a wrong sentence.
It's not a very happily worded sentence.
No, it's not very. I mean, the pleadings so casual.
Yes.
So casual and so imperfect. I think you have to tell the Law and Counsel that this is not the way to do justice. I mean, the client will ultimately suffer.
And Milords, there are. I've had the opportunity to assist senior counsels in the local bar. Their pleading, in fact, Milords, is not the point of concentration while pleading is very casual, as the lordship rightly pointed out.
Puri bar is one of the oldest and the best bars.
Yes, civil bar is very good, Milords.
Very good.
They're very good knowledge, Milords. I've had the chance to assist them. But it's only if your lordship sees my petition. Petition I was not showing your lordship because it's also that's a fallout of the casual approach, with due respect. But here, para 3 of my petition at
page 56.
Page 56. I'm obliged, Milords. Page para 3, it says that it is alleged by the petitioner in para 11 of the plain petition that OP respondent on her own whim has withdrawn herself from the society of the petitioner without any reasonable excuse and genuine cause on dated 24/7/24, and that the OP respondent willfully and deliberately neglected the petitioner.
No, in fact, I got your point.
Yes.
So suppose even if it is 11/7/24, it is maintainable. Order 6 rule 17, why they filed? In fact, you are also not convinced. Perhaps you are not saying the principle. But if it is cause of action is 24.
Yes.
24/7/2024.
Yes, bro.
So then also it is maintainable on the ground of desertion.
But desertion is 2 years from the date of desertion.
You are referring to?
Well, section 13(1), it's a small
Explanation.
Roman. Yes. If I may place it, Mullah.
Yes, please.
Your Lordship wants me to only place 1B or the entire provision?
No, that 2 year you are.
Yes. That your Lordship will see section 13, subsection 1.
Yes.
1B, it's a small I, small b.
A small IB.
Yes, please. Has deserted the petitioner for a continuous period of not less than 2 years, immediately preceding the presentation of the petition.
And cruelty? 1A is not have a time bar.
No, Milords.
Because cruelty is pleaded here. So in your written statement, you may take that plea.
But it's cruel.
But again, it will be the court will be in a real fix because it is stating that 2019 and 24 see lodges an affair. So 19 is the date actually.
But
so it is clearly within more than 2 years.
But your Lordship has must have gone through Order 7, Rule 11 judgments passed by the Honorable Supreme Court, wherein very recently in the judgments after Dahi Ben, which is 2020, there the Honorable Supreme Court mentions that if a date has been just mentioned for the purposes of bringing it within the purview of the limitation, then the courts can go into that and nip it at the bud because it is a frivolous and vexatious petition that does not deserve any merit in the trial.
But what about 19?
Yes, so therefore I was coming
You
to
are
19.
saying that since they have mentioned at 3 places 24
Yes.
and 1 place 19, so it should be 19. I think that will be a little bit too far stretching the logic.
So he can again file a petition. Let's say Lordship will kindly.
And 1A doesn't have any.
1A, my lord, save and accept that provision mentioned in the top of the petition.
No, they have stated, but treated with cruelty, he has mentioned.
Treated with cruelty, but he doesn't say in the cause of action that it is in fact the act of cruelty that has led to him filing the petition for dissolution of marriage.
And most likely that vexatious and false allegation criminal matter. So that is one of the ground in cruelty.
That might be,
because it has evolved that way.
But he in the petition itself, my lord, because Lordship is only to see.
I think this order which you are challenging is not against your client. Not exactly, because it says that
he plays it safe, my lord. With due respect, my lord, he plays it safe, saying that I am not to adjudicate.
Because if you are taking that plea in your written statement, it has to be a issue has to be flagged.
That is there, my lords. But
because at this stage, because now suppose he allows it, then what about 19 mentioning of 19 and that cruelty? So that will be challenged.
My lord, if he eventually comes to the finding.
No. At this stage only.
That's right, my lords. I'm saying that. So, if he eventually, while deciding this,
this order is not exactly against you.
Because I will have a chance in the trial also.
Not only that, if he has rejected it and then suppose it finally decides it, rejects the 13-month application, then the other side will come up before this court or the appellate court.
That's right.
Saying that what about 19 and cruelty?
And they will say that it amounts to reading between the lines of the petition.
Yes.
But I'll just take instructions to the effect that because it's a lawyer, my lords. So I'll just take instruction. It's a sister of a lawyer.
And ask him please to read CPC, Family Courts Act, and please at least be particular in pleadings.
Pleadings. But if I can only take instruction as to what your lordships have voiced today in the court.
Okay.
And also, Lord, if there is if I can file an application towards that
I think
conciliation.
That opportunity would be there.
Yes.
Because it's mandate of statute. Because otherwise the proceeding gets vitiated.
Yes, bro.
Because the language is sal.
It is mandatory. Your lordship is absolute. I bow down. So that, my lord, these two parts I'll take instruction. Lordship keeps it to next week.
So Soumya Misra for the item 14. Yeah, 14. The petitioner, the wife in the marriage is before this. You take your seat, I'll take it. The wife in the marriage is before this court, challenging the order dated 15/11/2025. Passed by the Learned Judge, Family Court, Puri, in civil proceeding number 392 of 2024, rejecting the prayer of the present petitioner in an application under Order 7, Rule 11 of CPC. Seeking rejection of plaint on the ground that the date of cause of action regarding desertion has been mentioned in the plaint of the petitioner husband, seeking dissolution of marriage and grant of decree of divorce under section 13 into bracket 1 to bracket I dash small a into bracket I dash small b, Roman name. As चौबीस 24/7.2024 and the petition having been filed in 2024. Can you get the date, Mr. Misra?
Yes, Malad, there is,
31 March 24.
it's in that verification it was there.
No,
Malad.
it's not. That is our stamp. Anyway, and the petition having been filed in the year 2024 itself.
Date to be put in.
The period contained in section 13 into bracket IV, 13 into bracket 1 into bracket Roman I, small b, right, dash small b, of 2 years was not complete. Stop. Perusal of the petition filed by the husband petitioner before the learned judge family court under section 13(1) to bracket I dash small a, then into bracket closed into bracket I dash small b indicates that at paragraph (11), the cause of action has been mentioned as 24/7/2024. Whereas at paragraph 17, paragraph 11, paragraph 16 लिखिए 11/16, the cause of action has been mentioned as 24/7/2024. Whereas at paragraph
17.
17, the year the desertion has been mentioned as since 2019, and at paragraph 18, the marriage was solemnized. The marriage is mentioned to have been solemnized on 1/5/2015. By the order, the learned family judge has observed thus. Learned counsel for the respondent submitted page quote tinta dot learned counsel for the respondent submitted up to for filing of written statement. Apparently, the issue raised before this, the issue raised in the petition under Order 7, Rule 11, has been considered by the learned judge family court. And also, the date of desertion mentioned in paragraph 17 has also been considered. Stop. This court is not going into the issue whether Order 7, Rule 11, whether a petition under Order 7, Rule 11 stricto sensu would be maintainable or not. However, apparently, however, it will be suffice to observe that the order 15/11/2025 is not prejudicial to the case of the petitioner hearing, as she has to file the written statement and she has the liberty to raise all the issues. Yes. Stop, not yes. Yes, Mr. Mason, when do you want?
That's any day next week or
Okay. The learned counsel for the petitioner has the adjournment to obtain instruction. List for fresh admission in the week commencing 18. Week commencing 18.
Oh, good. I'll try convincing you lordship with some judgments, my lord. I'll leave it to you. I'll take instructions as to this is because
No, because the problem is that once 19 is mentioned,
Yes.
the court cannot look the other way.
there's only one judgment.
Because then the court, what the court would be, I have dictated. Then
Yes.
what the court would be ultimately doing,
Well,
that court is selecting 3 paragraphs for you
yes,
and not looking at the other paragraphs.
well,
And obviously, it's
only one judgment I'll
when
show you, lordship.
both are competing as far as non-particular pleadings are concerned. Both.
I guess.
Both are, I mean, I don't know why it is happening.
Well, but now even a
At least
more
the good thing is that when you are asked about pleadings, I'm asking you, at least you are going through that and telling that, yes,
well,
there is a problem.
well. In fact, my lords, now a more situation has arisen by way of this AI. Because if it is used correctly, then it is a brilliant thing. If used incorrectly, it can lead to disastrous consequences.
Coincidentally, I was attending a conference yesterday on
Well,
AI.
well,
The entire day I had to attend that.
if it is used well, then it is
No, it is AI is struggling. My understanding is
That is right.
AI is struggling to
Yes.
match a human.
yes, absolutely.
Of course, we are threatened to a certain extent.
Well,
Our jobs are threatened and all that. But
it cannot replace the jobs, but it
is
can never.
impossible.
That's-
And maybe perhaps AI doesn't understand the date of digestion,
Yes.
the cause of action, what is cruelty,
In
what is
fact,
marriage.
judgment is uploaded to the AI system and a summarized format is sought for. Sometimes it gives the dissenting view in the full bench judgment. The dissenting view is given as the law laid down. That is dangerous.
In one conference, it was tested.
Well,
The person was asked that you file an appeal. In a narcotic case, NDPS case, the High Court has granted bail, so file an appeal challenging that before the Supreme Court.
well,
He could not understand, even if making him that right appeal by state,
well,
grounds of appeal. So that a lot is to be
Yes.
done by the AI, though, even the inventor of AI is not that excited as we are. I never find Sam Altman saying so many things that
Yes.
it can decide, it can find pleadings.
it's not true, Milans.
It's not correct.
Well, well.
And reading law is much more difficult.
Yes. I'm attached.
Yes. Yes, next.
Item 16.
Mr. Bhavani Prasad Samal for the petitioner.
Yes, my lord.
Yes, please.
May I please your lordship, my lord, in this case, petitioner challenging the order passed by the Lok Adalat.
Sir, जहाँ document fresh matter रे चिट्ठा भलिया बढ़ांतुनी आपण amendment करंतु. I cannot take up as papers.
No, my lord. I am
आपण straight away come to the point.
no, my lord. I am
यदि किछ rely करूचंती record को आणंतु.
No, rely. Amendment petitioner, some of the party has not been added.
Amendment एटी फाइल करूचंती. एटी काचो भांगियो को पड़ियो.
Aye.
ए सो काचो भितर इमेज रे अछि. एटी फाइल करिवे. आपण चाहउचंती application फाइल करिवे.
Aye.
ठीक अछि.
Today I am
Mr. Bhavani Prasad Samal for the, you are Mr. Samal?
Yes.
Bhavani Prasad Samal for the petitioner. The petitioner, Lord Counsel for the petitioner submits that the petitioner seeks to amend the application. Accordingly, prayer is allowed. Accordingly, steps be taken by the petitioner. Kete din re file karibe?
Today I am
Within 5 working days, the scanned copy be updated. The amended application shall be taken on record. Scanned copy be updated. केबे आसले हम?
next week.
List for orders. Next week sir 18 4 दिन अछि sir.
Next week आज
ଗୋଟେ ଦିନ ପଖାଳ ଅଛି ଆପଣ ତ already ତାଙ୍କୁ 115 ଟା ଆଜି ଆଉ 5 ଟା 120 କରି ସାରିଲେଣି. List for orders in the week commencing 18 5 2026. Yes, next.
17.
Praying for the Passover.
Passover. Yes, next. Passover মানে after recess. Time হয়ে গেল. Yes, sir.
May I please, Your Lordship? My Lord, last occasion, Your Lordship has asked me to demonstrate where the demand draft entry
नहीं
memo
नहीं टी ऑर्डर टा देखन जहाँ कहिची तो मु रेकॉर्ड करथिबि ना
5-3 of 2026.
आपन ना सर
Sanat Sushovan.
so SS Sanat Sushovan Panda for the petition opposite party के appear करना है
No, my
fresh
Lord.
matter the orders rest
Notice not.
को order टा refer करछन आपण
5-3 or
5-3
yes,
okay.
sir.
से ड्राफ्ट पारा 2 देखिने read paragraph 2 आपण you should use this आपण कोन आपण के एज रे आपण माने तो पेपर यूज करिया कथा कोन पारा 2 on being asked after preparation of the demand draft.
My lord,
What is it?
I have filed an affidavit on that light. It is at paragraph flag E.
Flag E.
Yes, your lordship. I have annexed the orders passed that the demand draft has been given.
कोडी देखले को पेज रे अछि
My lord, flag E, page number
5.
Yes, your lordship.
When you are submitting, always refer to the page, paragraph, flag. ED bearing 221752 dated 19/2/26.
Yes, your lordship.
1,80,000. Okay. That you have deposited and she has been directed to receive. Appearance लिख ले बतो. The learned counsel for the petitioner refers to the order dated 5/3/2026. Paragraph 2 and submits that he has obtained copy of the order passed by the learned executing court. And executing na family court.
Family court.
Who matter? Flag E कहले ना?
Yes, your lordship.
He has obtained copy of the execution I got family court. So case 4 देखो तो. He has obtained copy of the order dated 22/26 filed along with affidavit dated 13 March 2026.
Yes, sir.
13/3/2026. So the said affidavit is on record marked at flag E. Perusal of the order dated से जो order टा लिखिबे dated 20/2/2026 passed by the learned judge family court comma Jagatsinghpur in CRL.E.execution EX. Number 29/2022 indicates that the learned judge family court has observed. Quote करते हैं 22/2/26 the case record is put up to the Now it is apparent that the petitioner has paid the amount of rupees 1,80,000 towards area. Thereafter has also deposited rupees 20,000 on 15/5/2023. Apart from, not thereafter, apart from that, he has deposited rupees 20,000 on 15/5/23 and rupees 10,000 on 20/2/26. You are challenging the quantum or the liability to pay maintenance.
Liability, ma'am.
You are not willing to pay any maintenance.
No, my lord. I am challenging the quantum because
Quantum,
because the Rajneesh versus Neha affidavit has not been filed in this matter.
Affidavit file न कले दिया हबनी बोली सेटा को पैराग्राफ रे अछि.
My lord,
Rajneesh versus Neha जो पढुचंती ए आर्गुमेंट ता कले I have checked it because you are submitting, so others are submitting, but that is nowhere. And when the quantum of maintenance is very less, 5,000 7,000 पे अपन affidavit करी के देबे तापर determine करिवे, does it solve any purpose?
my lord,
So say sense the order is not there. If because it is a 140 to 141 you are citing article. If the Supreme Court has said that no court can award any amount towards maintenance if affidavit is not filed, then your submission is correct. But I have tried to find out, but it is not there. So upon jodi bi achi thale just please tell me that specifically. That would help. I am issuing notice today, but you find it out. Para. The petitioner husband challenges the order passed by the Learned Judge Family Court Jagatsinghpur in by judgment dated 6/5/2022 in CRL dot P dot number 79 of 2019. Stop. The said application was filed by the wife in the marriage under section 125 of CRPC, claiming maintenance, monthly maintenance, along with the minor child born from the wedlock, represented through the mother guardian. This court takes note of the fact that the petitioner has deposited an amount of paid an amount of rupees 2,10,000. 2,10,000 ଆଉ କେତେ ଅଧିକା ଦେଇଛନ୍ତି?
My lord, we are also continuing payment.
2,10,000 towards arrears and continues to pay the amount of maintenance of rupees
7,000. 4,000 for the
both mother and child.
Yes, sir.
And amount of rupees 7,000 as monthly maintenance to the both for both the mother and the wife and this child. You should notice along with this order. Should notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days or 3 working days. Within 3 working days. Returnable date we fixed to 6/7/2026. The matter shall be listed on 13/7/2026. Now the trial court is proceeding with the execution. That you want stay. So that upon annexure lagi re achi. Okay. IA number.
My lord, it has been filed way of affidavit only. IA not filed.
Stay पर आप IA टा 22 देखो. IA 22. और IA number जो 22 IA 22 of 2023. ना. Hard learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Stop. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. So, in the interim, it is directed that the execution case number 29 of 20222 pending before the Learned Judge Family Court Jagatsinghpur arising out of execution number टा कितने पकड़े? पूरा लिखो तो CRL dot P dot EX number 29 of 2022 arising out of it लिखिए shall be adjourned beyond कितने डेट कर लो 13 beyond 20/7/2026 to a date as would be convenient to the learned court in season of the matter. Urgent certified copy as well. Yes. The rest of the matters after recess, Mr. Mahanti, we are waiting for.
I pardon my lord.
Sir, 24
item number 4, 24, 25, 4 and 40. In all these cases, I have solved a copy on the other side. Let it come in some other date after vacation.
Mr. Das, Learned Senior Counsel, along with Mr. P. Das were present. They mentioned on your behalf. They request Mr. Das, you serve copy on the instructing counsel, Mr. Das. How much time? कितने दिन 3 दिन में देबे कॉपी?
हां 3 दिन आउ दिटा रहला 4 ଆଉ 40 एकाठी आछियो
सेटा तो
आइटम 4 एंड आइटम 40
सेटा आपन मेमो देबा पड़िबो सर
नहीं सेम
आपन 24 और 25 रे दियंतु कॉपीटा
आया
it will come on in the week commencing 13/7.
Yes my lord. Yes. On the same date, all the other 2 cases may be listed. Other 2 cases माने 4 and 40.
काकू कोंतु देखि कि देबे कोर्ट मास्टर को आनी कि दियंतु का कोंतु अब आइटम 48 टा कोन 48 कोन चाहउछंदी सर
40 टा हियरिंग पे अछि सेटा से डेट को आसबे करता क्या सेम acquisition same village everything is same that's why
project proponent also Paradip Prospect.
Yes madam Paradip Prospect.
ठीक है 40 से विषय
40 and 4
वो जोटा पास ओवर इच
item 4.
Chari also Paradip Phosphate.
Yes, madam. Paradip Phosphate.
Or copy on Mr. Das.
All the 4 cases Paradip Phosphate.
Yes.
Paradip Phosphate, same acquisition, same notification.
Praveen Das, hello, Mr. Sushant Das, senior advocate, along with Praveen Das. Yes, Mr. Mahantu.
28.
Yes.
Mr. Behra is saying there are other matters coming in the after recess, some Supreme Court remand matters. So,
Mahanadi Coldfield Ray.
No. Your lordship is hearing some other matters.
That's
yes. There is a special bench. Right.
So this may not reach.
Yes.
28 maybe.
So actually what they have noted,
Yes.
after long this bench may continue after exhaustion of the special list.
Yes.
But how others will wait? So that is the thing. So that is the problem.
But 28.
The pleadings are complete melodies, and my learned senior has supplied this copy of the ordered melodies. It is to be heard melodies.
So when do you want? After vacation?
After vacation. An interim order to continue.
Okay.
Lordship kindly see last order dated 7/4.
Yes.
7/4/26 your lordship has already.
Okay. केबे को आसले हम for admission? Order pass कर 27. We commencing 27. Along with Mr. Mahanti, Mr. Sharma, you are there.
Item 39, my lord.
No,
Interim order.
Yes, I have noted.
The last order your lordship has taken.
Yes.
7/4/26.
7/4. I'll check it.
Yes, 7/4/26.
I'll pass that order. After I come back, I'll pass that. Yes.
My lord, I complete 34.
30, 33, 34. Yes.
Some other thing.
After vacation, etre pleadings achi.
Pleading 33 complete.
Acha.
30 and 34, my lord directed for settlement of his in amnesty scheme.
Amnesty.
And till now, not final in this scheme.
अच्छा ठीक अछि केबे को आसले हबो वैकेशन परे 30 देखंतु 20 7 देन 33 20 7 anyone from Mr. Mishra chamber
34 or
Mr. Narendra Mishra कर inform chamber के नांति 34 Mr. Mahanti were there. 34 केबे? 39. Okay. You will
For the petitioner.
So Sipsankar Mahanti?
I've already intimated.
So after the special, yes, he's there. So after this special bench, would you wait or it will be?
No, after vacation.
केबे date करंतु?
We concern 27.
Mr. Mahanti 27 week?
after let it come after vacation.
Yes, 27. आपनकर third week after vacation.
My lord.
Intimate to continue.
That is the fourth week.
Intimate to continue.
Interim order. Interim order कौन था? Adjournment फिलहाल.
Stay for the petition.
Stay I am not touching.
Still the
Stay I am not touching.
The order is till the next date, my lord.
देखिए दाओ, ठीक है, I'll see. Yes.
My lord, my matter is not on the list. I'll wait till my landed seniors have mentioned for on the list.
ଆପଣ ଚାହୁଁଛନ୍ତି listing ପାଇଁ?
Yes, my lord.
Memo ଦେଇଛନ୍ତି?
My lord, last week
ଆଉ ଗୋଟେ memo ଦିଅନ୍ତୁ.
my learned senior had mentioned that OCA election matter to be listed on this week. I was checking on the website. It's listed on 14/5 on 2026 on Thursday. My learned senior is not available. Your lordship.
ସେଇଦିନ prepone କରିହବନି. ଆପଣ ସେଇଦିନ mention କଲେ it will be accommodated.
My lord, your lordship has told to week commencing 11. Then the special matter is.
So actually, see, if I remember, Mr. Palit.
Mr. Palit. Yes.
So he was not available after 14th.
Yes, my lord.
So that is how it has. So he's not available on 14th. You are saying.
Yes, ma'am.
So that was a mistaken understanding. So I thought that he'll be available on 14th because he was present. So that is how it was gone to because 11th today, 12th or 13th you want? Or what?
12, 13, anyway.
कौन करेगा उसे? ଆପଣ ପ୍ରିପୋନ୍ କେମିତି କରିବେ ତାକୁ 14 ଆସିଲେ ସିନା ମେନସନ କରିବେ ସେମିତି ତ କରିବାଟା ଠିକ ହବନି because now it is not on board na there's maybe what you are saying is correct but it was understood that is available on 14 so that is how yes other matters will be distributed whatever is left out not mentioned if you want after vacation he will give you a date whatever if you want before vacation it has to be distributed because before vacation we have now 120 we have reached.
My lord, item 20 will be taken on, my lord.
Item?
After lunch, item 20, order matter, my lord.
Order sir যেତିକି ରହିଲା 20 ସେଟା ସ୍ପେଶାଲ ବେଞ୍ଚ ପରେ ଆପଣ ଦେଖିବା ଟାଇମ ମିଳିବ ନହେଲେ କରିହବନି ଆପଣ ଡେଟ୍ ନେବେ ଯଦି ଯାହା it is your choice.
It is urgent matter, my lord.
Sir, there is a bench is not available at 2. At 2 there is a different bench. There is a special assignment by the Chief Justice. Master of roster.
Tomorrow, my lord.
Tomorrow ନାଇଁ ଯୋଉ ଦିନ ସେ କହିବେ ଆପଣ ଓଡ଼ିଆ ଯଦି ଆପଣ ଚାହୁଁଛନ୍ତି ସେ ଯୋଉ ଦିନ ଆଡଜଷ୍ଟ କରିଦେବେ ଦେଖିବେ Mr. Ashok Kumar Behra for the petitioner.
Recording in progress.
My lord, present petitioner is the father-in-law for.
But there is another. There are another 2 Ashok Kumar Behra.
Three. I am 3.
You are 3.
Yes.
Correct.
Difficulty is that, my lord. Difficulty is that, my lord. Last occasion, Ashok Kumar, mo power Ashok Kumar Behra 3 कहा. से कटी है जिसे 3टा बोली के जानी पहले नहीं लिस्ट टा ये मोबाइल में भाग करते तो लिस्ट टा अच्छा प्रॉब्लम
पेपर 3 कर दियो तब तक ठीक है yes
आया present petition is the father-in-law of opposite party 2 my lord.
Yes.
Challenging the order dated 11/2/2025 my lord.
Yes.
In passed by the Lawn Family Court Noyagada in IA number 21 of 24 arranging out of CPK 70 of 2023 my lord.
Order 9 rule 30.
Annexure 1 my lord. Annexure 1 page my lord 13 my lord. It is a expiry order my lord. Order is that the awarding amount is 15,000 maintenance award my lord.
What place कले?
My lord.
Order 9 rule 13 टा reject है ना कौन है?
Yes my lord.
पढ़ो. This case is posted today, page 11.
Page. Yes ma'am. Yes, posted today for orders on the office note showing delay of 8 months 9 days in filing petition under order 9 rule 13 of CPC by the petitioner had on the petition for condonation of delay under section 5 of Limitation Act. The loan advocate for the petitioner submitted that there is absolutely no service of notice on petitioner in CP 70 of 2023 my lord. And he submitted that postal track consignment report showing that someone was delivered to the petitioner is a false one and further submitted that petitioner is suffering from Parkinson disease my lord. Present petitioner. And unable to appear in the proceeding of CP of 70 of 2020.
Para 3 पढ़ो स्टेट para 3 पढ़ो. अपन execution appear कर चलती.
Again?
Execution नहीं हुआ appeared. पढ़ो तो para 3 पढ़ो तो.
Yes. Para 3.
It is on record that
petitioner has already substituted in execution case in CP execution number 9 of 2024 before this on this court for recovery of secretarial amount of 2,25,000 in arrears towards maintenance from the petitioner. The petitioner appeared in that proceeding 11/9/2024 and he had to file show cause in that case. I do not agree that the petitioner was unaware of proceeding against him So in CP 70 of 2023, the petitioner was very much prosecuting in the proceeding against him under the PWDB Act in CMC 143 of 2022.
Here, before the
Before-
ATGM Noyagada.
ATGM Noyagada.
To say that by him, then
That he could know about the proceeding of execution against him after he received the notice in CP 9 of 2024. Man. Considering the amount of decretal dues outstanding against the present petitioner, that it is clear material show that he deliberately avoided the receipt of summons in proceeding in CP of 70 of 2023. I am considering view that the no notice we issued to the OP for each appearance in the proceeding to consider setting aside the order and decree passed in CP 70 of 2023 proceeding under section 19 of Hindu Adaptation and Maintenance Act instituted by the daughter-in-law of the present petitioner. The expected judgment and decree passed in CP 70 of 2023 can given force against the present petitioner in CP execution case number 9 of 2024 against him. Hence, proceeding IA number 21 of 2023 dismissed in line.
or execution case 9 of 2024 could arises out of
IA number 21 of 2024.
CP number 9 of 2024 CP execution ଟା କୋଉଥିରେ ଆରେଞ୍ଜ କରୁଛି ଆପଣ ସେଟା ସବୁ ଚେକ୍ କରିଛନ୍ତି ନା ନାହିଁ
ଆଜ୍ଞା
ଆପଣ ଯଦି ସେ ଯୋଉ କନେକ୍ଟେଡ ମ୍ୟାଟର ଗୁଡାକ ଚେକ୍ କରିଛନ୍ତି ଆପଣ ଯେତେବେଳେ ଗୋଟେ ବୋଲ୍ଡ ଷ୍ଟାଣ୍ଡ ନଉଛନ୍ତି ତାହେଲେ ଆପଣ ଆଲେଜ କରୁଛନ୍ତି ପୋଷ୍ଟାଲ ଏଗେନ୍ଷ୍ଟ ନନ୍ ସର୍ଭିସ
ହଁ
କେମିତି କଲେ what is the basis
the basis
check କରନ୍ତୁ ଆପଣ
ଆଜ୍ଞା
the same problem whatever the client says that you don't belch it out before the court ଆପଣ ନିଜେ ଆଗ check କରନ୍ତୁ so that these
Yes,
questions you have to ask the client then you have to check the proceeding in execution then the other of course 143 of 2022
yes
then you can make your submission ବର୍ତ୍ତମାନ ମୁଁ ଆପଣଙ୍କୁ ପଚାରିକି ଏଗୁଡ଼ା ସବୁ ଆସିଷ୍ଟ କରିବା ଅପେକ୍ଷା you should get prepared
ଆଜ୍ଞା ଆଜ୍ଞା
yes
so here
the learned counsel for the learned counsel for the petitioner the petitioner father-in-law of the opposite party before this court and Mr. Behra I don't know what you have thought about the legal strategy you should have challenged you can challenge the expertise in merit also
yes
by filing appeal revision whatever what you are challenging now order 9 rule 13 only
yes
all those things you have to consider
ଆଜ୍ଞା ଖାଲି simple notice
simple notice ହୋଇପାରିବନି see Lalita but I have already delivered a judgment that I cannot issue notice in every matter I should not have you checked
it is requirement
CPC
as
order
because
47 rule 10
it is requirement as because she file order PWDB Act file करছে and she is also entitled for that
अरे आपण मेरिट रे चैलेंज करना दे आपण कहउछन जे मु नोटिस इशू करिवि त हैव यू चैलेंज दैट ऑन मेरिट that was the last question to you by going to that side and I'm assisting you
expert
it has to be expertise
present petition
and how did you appear in the execution and defend it
in execution
execution arises out of which order
execution matter come to matter
so so that question I asked you you did not answer so then I realized that you have not checked that way or you have not been briefed this is not the way to handle litigation sir I don't know what is happening to trial court lawyers if you are appearing in execution and saying that I do not have a notice how can the court will take cognizance of that
yes
and Alzheimer for only this maintenance application for DV no Alzheimer execution no Alzheimer how the court will justify its order you must understand that
yes yes
the petitioner is the father-in-law of the opposite party for this court challenging the order passed by the learned judge family court Noyagad in IA 21 of 2024 arising out of CP number 70 of 2023 The said IA is filed under Order 9 Rule 13 of Civil CPC
I have filed.
by the present petitioner for setting aside of ex parte judgment dated 15/12/2023. The petitioner disputes the postal tracking report. Disputed the postal tracking report before the Lord Judge Family Court. The basis of such dispute is not disclosed in his application. Para. The postal tracking report, postal tracking report regarding sufficiency of notice. Regarding sufficiency of notice in the CP. Para. Rejecting the for rejecting the order application under Order 9 Rule 13 by order dated 11/12/25.
11/2/25.
Sorry, 11/2/2025. The following reasons have been the following analysis as well as reasons have been given by the Lord Judge Family Court. This case is posted today to Neki. Para Purada reproduced on them. The reasoning given by the Lord Family Court can be summarized as the postal track consignment report is suggested to be forced one by the petitioner was without any basis or without reference to any material. The petitioner appeared in CMC number 143 of 2022 before Lord SDJ Noyagad and has contested the same, being the opposite party. Which suggests that his plea of suffering from disease, Parkinson's disease, and inability to appear is not correct on his own showing. The petitioner himself, the petitioner has appeared in C.P.exn number, exn. Case number 9 of 2024 for recovery of decretal amount of rupees 2,25,000 in arrears, wherein the petitioner has appeared on 11/9/2024 and has filed so cause. Therefore, the plea that he is unaware of the CP 70 of 2023 is untenable. But the Lord Counsel for the petitioner has adjournment to obtain instruction, verify the details of the cases, as well as pleadings before the Lord Trial Court to address further. The matter shall be listed for fresh admission in the week commencing
1st July.
29 July 1st କହୁଛନ୍ତି 1st July ରେ ହେଲେ 84 ଟା ଅଛି 13/7 ରଖନ୍ତୁ 13 week commencing 13/7 ନା ଜୁଲାଇ ଚାହୁଁଛନ୍ତି ଆପଣ ଫାର୍ଷ୍ଟ ୱିକ୍
No, first to
6/7 ରେ already there are about 100 matters posted
29/6.
ତାହେଲେ
29/6
ଠିକ ଅଛି 6/7 ରେ ଆସୁ 6/7/2024
ଆଜ୍ଞା
Achor item 17.
Court ରେ ବି order ଡକା ହବ ନା Court
Achor item 4.
Mr. Kishore Kumar Jena for the petitioner, Mr. Praveen Das.
One.
For Mr. Leka, who was there I'm just dictating the orders.
Item 4.
4.
I'm to.
So Prem Kumar.
Adjournment. Sukmar Behra 3.
अच्छा अशोक कुमार बेहरा गैस इंग्लिश 3 कर दो.
Yes. Listed project.
Again.
Duplicate.
Again. Mr. Prabhu or Mr.
Item 4 में Prem Kumar Math.
Prem. Mr. Prem Kumar Mahanti, Additional Standing Counsel. Mr. S.K. Das, Senior Counsel, along with Mr. Robin Das for the opposite party number 2. All right, it is submitted by the Learned Counsel for the Learned Counsel, instructing counsel for opinion number 2 that they may be provided with a copy of the appeal memo. The appellant respondent. Copy of the appeal memo. The Learned Counsel for the petitioner, for the appellant submits that he shall serve the copy within 3 working days. Okay. The matter shall be listed for fresh admission in the week commencing 13/7/2026. 24 ରେ କିଏ ଅଛନ୍ତି?
17ଟା ଇୟର ଅଛି।
ଜେନା ମ୍ୟାଟର ଦିଟା ମେନସନ କରିଥିଲେ।
ପ୍ରଭୁ ପ୍ରସନ୍ନ
24 ରେ ପ୍ରଭୁ ପ୍ରସନ୍ନ ଅଛନ୍ତି, 25 ରେ ବି ପ୍ରଭୁ ପ୍ରସନ୍ନ। 24 ରେ ପ୍ରଭୁ, 25 ରେ ପ୍ରଭୁ ଅଛନ୍ତି। ସେ 7 working days କହିଥିଲେ ହେଲା, 7 କରିଦିଅ, ସିନ୍ କରନ୍ତି ସବୁଗୁଡା 7 କରିଦିଅ। 4/24/25 ସମାନ ଅଛି। ପାର୍ଟି ନାଁଟା ଦେଖିବାକୁ ପଡିବ, ପାରାଦୀପ ସସ୍ପେକ୍ଟ ପାଇଁ ଆଫେୟାର କରୁଛନ୍ତି ଯେ ପ୍ରବୀଣ ଦାସ, ତାଙ୍କ ନାଁଟା ଦେଖିଦେବେ। ସେ ହେଇଥିବ ସେମ୍ ପାର୍ଟି ହେଇଥିବ, ଓପିଟ R2 R1 ହେଲେ ଏସି। Yes. Item 40.
Item 17
40ଟା ଆପଣ ସିମ୍ପଲି ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ। ସେଟା କଣ ଅର୍ଡର ଦରକାର ଆପଣଙ୍କର? ଅର୍ଡର କଲେ ଦେଖୁ ସମୟ ଲାଗୁଛି। ପଢିବାର ନୁହଁ, 40ଟା will not reach। ସେ 13/7 କରିଦେବେ।
Item 17.
May I please, Your Worship? An application for a proceeding for restitution of conjugal right has been issued.
Yes.
At the behest of the wife, it was transferred to Cuttack. It is pending at Cuttack.
Yes.
Way back on 21/8/2025,
Yes.
Your Lordship will kindly turn to page 13, Annexure 1. An application for visitation right was filed by the husband.
Yes.
By the father.
Just one second, I'll get the file. Actually, I'm in the other specialist, so what I was dictating was Visitation contract right was filed, you said?
Restitution of conjugal right was filed.
Yes.
That
restitution
was
filed by husband.
Husband.
Okay. Visitation contract right with the child.
No, restitution of conjugal right petition was filed. Proceeding was filed.
Yes.
At Baleshwar.
Yes, it was transferred to Cuttack.
Cuttack at the behest of the wife. No issues, my lord. Parties are appearing here. Now, I filed a petition for my visitation right because wife did not allow to meet the 2 kids.
Child. Yes.
That was filed way back in 21/8/2025. And last of the date was on 16/3/2026, on which date the case got posted to 15/5. That is coming. In the meanwhile, I filed this writ, and before the writ could come, the time also has come. Now, the IA is not being taken up. My only limited prayer with your lordship, it is there for 15th, on 15th, let him decide the issue, hearing both the parties.
You are saying that, can you suggest from the order sheet that it was never taken up, visitation contract rate?
No, that is being...
Is it a section 26 application or independent application?
It has to be 26, my lord, because it's not a separate case, it is emanating from
26.
It is emanating from that. So, my lord, that has to be decided. And some kind of right, like I meet my children.
No, I mean, visitation and contract rate, there is no custody application, no separate application by any of the parties.
No, an application by me.
Out of the 9 only.
Yes, out of that proceeding only. Yes. Your Lordship will kindly see that is a page 30, visitation right of children in a week. That means সপ্তাহକୁ থরে।
So he will decide that after deal with that after hearing the parties that much.
I'm no dispute. Now it is posted to 15/5. সে ডেট দেলা বেলে 2 মাসে এইগুড়াক 2 মাসিয়া ডেট হুয়েনি। মেন কেস মে বি ডিসাইডেড ইন ডিউ কোর্স নো ইস্যুস।
But you are saying that
এটা
ফাইল হেকি ফাইল হবার হেলানি বর্ষে উপরে হেলানি।
হ্যাঁ 28 মানে হেলানি 9 মাস 9 মাস হেলানি। তেণু এইটা টিকে জলদি
the petitioner the husband in the marriage is petitioner before this court. Appearance like that. So Samir Kumar, Mr. Senior Advocate, along with Mr.
Rakesh Rao.
Mr. Rakesh Raut for the petitioner, opposite party blank. You have your seat. I'll just complete that. The petitioner, the husband in the marriage is the petitioner before this court. He seeks he raises a limited grievance to the extent that his IA number 95 of 2025 filed by him in CP number 75 of 2024 pending before the learned judge family court Cuttack should be taken up. Considering the limited nature of prayer, this court is of the considered view that taking up of the said IA is inter alia seeks visitation and contact rights with the children emanating from the CP What sentence the completed? Arising out of it. One child or children?
Children, two
children. Emanating from the arising out of the CP filed by the wife under section 9 of the CP টা भी अपने wife file করছেন
No, husband file.
আচ্ছা emanating from the application filed by the husband under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights would not adversely affect any of the parties. The learned judge family court shall do well to consider the same by hearing both the parties and pass appropriate order. The petitioner hearing shall produce certified copy of this order before the learned court to do the needful.
I was only praying some kind of observation that he should take up this with promptitude because it is posted to
people. Problem ଅଛି.
Ne mu
Allahabad Bar Association.
ସୁଯୋଗ ଦେବେନି ବୋଲି ମୁଁ କହୁନି.
No, because now you might have got a hint why I was asking it's the section 26 application or any other parallel proceeding is pending for custody. So maybe I don't know how many cases are pending, how many custody applications are pending.
Custody ଆମେ ଲେଖିଛୁ ଆମ application ରେ children are not to be tossed off from one parent to other. ଆମେ ବି ଲେଖିଛୁ we are conscious. We want a limited visitation right.
Targeting a matter, the Supreme Court has very strictly said that
he should.
High Court should not.
No, targeting.
But I have said that
it is posted to 15. That
whatever. So you have to produce. मुझे ना था आगुरी विषय डेट देने और 15/5 रे अपन प्रोड्यूस करिए बोल देंगे.
I can date is posted to 15/5.
It is submitted by the learned counsel for the senior counsel for the petitioner that the matter is posted for posted to 15/5 2024. So that will be taken up and dealt with by the court. Yes.
Your Lordship may grant a urgent copy because today is 11, so
yes.
It has to be.
Yes.
28
Mr. Sanjit Mahanti, Senior Advocate, along with Mr. Rakesh Sharma for the petitioner. So Prabhu Prasanna Behera. Additional standing counsel for the opposite parties. The matter being in the list is the matter is listed for hearing under the heading for admission stop. Due to paucity of time, it is mentioned by the learned senior advocate for the petitioner. Stop. The matter shall be listed for admission in the week commencing 27-26. The interim order dated 23-11-26 shall continue till the next date of hearing. Yes.
Special.
What?
Special.
Special is happening in so what order so doka hai
Special list item 1.
With permission of my grand senior, I have filed an additional affidavit that is in your lordship's board with all documents. Other day your lordship made queries regarding the contract and the everything. I
that is available annexure 1.
You
are disputing annexure 1, then it's a different thing.
No,
but I cannot. If you are not disputing, then I have to look at annexure 1.
Yeah,
Suppose you are now looking at another document, then it's a different.
My humble submission is that annexure B/3 to my additional affidavit that it is a partnership firm. The government has
What pine it you wrote?
B3.
Affidavit dated?
Affidavit dated
5/5/26.
हमको सवाल मिला वे 6 नहीं ये लिखी ना था कि वे सर
नहीं गई याद
अच्छी your lordship in the cost title it is so your lordship में can see
अच्छा maybe move खोजे था I think the writ petition number is
31548.
Yes, I have opened that.
Yes.
Counter देखो ची rejoinder.
Yes.
क्या नहीं
Then thereafter
reply to rejoinder.
Yes, just thereafter, additional affidavit filed by OP3. That is but it is shown.
Last working day पूछ रहे थे लगी.
Ticket again.
8 so 8 के पूर्व उटा फाइल ही जी.
हम 10 देखो.
Cost title देखो चला.
नहीं आपनकर जो cost title क्वेश्चन सेटा कोट आसला.
Your lordship saw that
more cost
reply to the rejoinder filed on behalf of the opposite party are kept in place.
So last noting is NCR.
No. In middle, your lordship. In the middle. Just after the reply to rejoinder.
तापर अच्छी मोर वकालतनामा तापरे
additional affidavit filed by OP3 memo.
Yes.
It
memo
again
memo ता अपन देथिले
memo along with certified copy
सेटा अपन
ता पूर्वरु अछि अपन गटा
additional affidavit by OP3 that is deputy director match
additional affidavit OP3 para filed by OP3 yes this is also OP3 OP3
थोड़ा पेपरलेस देखा जाउची
OP3
क्लिक करले कोटा
P3
31548 कोटा
P3
rejoinder reply to rejoinder तापरे कोन अछि तापरे आइए अछि
flag D for vacation of interim order then counter affidavit filed by
डिपार्टमेंट नहीं हो
rejoinder तापरे memos have been filed to adopt then memos at flag E then reply
फ्लाइट के मैच करूनी कोन एटा आपनकर मोर के मैच करूनी कोन
same rate मैं देखो 31548
नहीं मैं आपको पचास सेठी जाई देखिले
रिकॉर्ड टा करने
पढ़े जैसे आरा पढ़े जे देखो
रिपोर्ट सुने ये देखो
रिकॉर्ड टा जल्दी
additional affidavit filed by 15 numbers
ब्लैक मार्क किसी करना है
मैं फ्लैग मार्क करना है।
ब्लैक मार्क करने से प्रॉब्लम होगा
The last, nahi? The lordship is right, probably the national.
और এটা देखो तो
It's not
ये
this.
लेखा सार में जब वो नहीं चेक करेगा
Nine, according. Your lordship is right, it's not there.
नहीं से जो
Asin.
8 ର ଆପଣଙ୍କର ଏଗୁଡା ତ 8 ରୁ ଆସି ଯାଇଥିବ ନା ତ ଭେରି ପ୍ରକ୍ସିମେଟଲି ସେ ଫାଇଲ କରିଛନ୍ତି
Asu scan ହେଇନଥିବ ଯଦି
ସେ ହେଇଛି
ସେଇଟା ତ
8 ରେ ଯେହେତୁ ଏଟା ଲିଷ୍ଟ ପୁରା ପଳେଇ ଆସିଛି
ଓଭର ସାଇଡ୍ ରେ ହେଇନଥିବ କି ଆପଣ କୋଉଠି ଆଗରୁ
ମାନେ ସେ 7 ରେ ଫାଇଲ ହେଇଥିବ ଏଟା ଫିଜିକାଲ କପିଟା ମୁଁ ଜାଣିନି ଆକ୍ଚୁଆଲି
5 ରେ ସେମାନେ ବୋଧେ ଫାଇଲ କଲେ ଫିଜିକାଲ
Online-
6 ରେ ଆମକୁ କପି ଦେଲେ
6 ରେ ଫାଇଲ
6 ରେ ଫାଇଲ ହେଲା
ହଁ ତାହେଲେ
ଆଜ୍ଞା ଆଜ୍ଞା ନାଇଁ
नहीं हियर इट इज
ନାଇଁ ନା
अच्छा
ଅଛି ରେକର୍ଡ ଅଛି
ସ୍କାନିଂ ହେଇନି
ସ୍କାନିଂ ଟା ହେଇନି ସ୍କାନିଂ ଟା ହେଇନି ରହିଯାଇଥିବ ବୋଧେ ଯୋଉଠୁ
ସେଟା ଡେମୋ ନା କେତେ
ମେମୋ ପୂର୍ବରୁ ଜଷ୍ଟ
ଫ୍ଲାଗ ଆପଣଙ୍କ ଲଗେଇଛନ୍ତି ପଢ ବି ଗୋଟେ ଆପଣ ଗୋଟେ ସେଇଟାକୁ ଅନନେମ୍ ଫ୍ଲାଗ କରିଦେଇଛନ୍ତି ହଁ ଲାଇକ୍ ଇନ୍ ଷ୍ଟେଟ୍ ଅଫ ହରମୁଜ if you fly with a particular flag you are like to be fired at so what they have done so they have they pasted a flag without anything obviously not scared
ଆମ ତେଲ ବାଡା ସେମିତି ପଳେଇ ଆସିଲା ମାଂସା
ଆମର ତ ବନ୍ଦ ହେଇଗଲା ପୁରା
ଆମର ବନ୍ଦ ହେଇଗଲା କମ୍ପ୍ଲିଟ
in fact CNG has completely stopped
କମ୍ପ୍ଲିଟଲି ଷ୍ଟପ୍ ଗ୍ୟାସ୍ ବି ପ୍ରୋବ୍ଲେମ ହେଲାଣି
annexure B by 3 मैंने page 60
that index कॉल index करना है page रे अछि
index ଅଛି
अच्छी अच्छा B by 3
yes sir page 16 I'm
page 16
yes page 16 second I'm pressing second third part check from second part whereas the minerals in the land in respect of which
ସେଠି ଆରମ୍ଭରୁ ପଢି ଦିଅ
अच्छा
so that you get the context
yes
the annexure B by 3 page 16 press
yes, yes sir subject grant of renewal of mining lease in the district of Keonjhar for iron and manganese ore. Read application prescribed on 2192 by Messrs. H.D. Pandya and others for grant of second renewal of mining lease for iron manganese over an area of 243 hectares, subsequently revised to so in village Jajanga and Bhulabeda in the district of Keonjhar. Order. Whereas Messrs. S.G. Pandya and others have applied to the state government for grant of second renewal of mining lease for iron oblique manganese over an area of so and so, revised to so and so.
Supreme Court Leka,
Yes, sir.
you are relying on this Supreme Court has struck down this
No, my lord.
that second renewal is not permissible after that
No, this is in the year
Supreme
1994.
Court has struck it down. So suppose let us assume that you rely on this. I
Yes.
will not observe that.
No, I am relying on this.
No, I will not say. But have they apprised you that regarding?
No, we got the grant. We
No,
got.
which is the decision? I will check the decision.
No, pursuant to this.
All second renewals made by obviously the renewals are by the state government,
Yes.
not by the party themselves. These are all mining leases. Second renewals have been struck down by Supreme Court way back in Goa Foundation. So this person who has briefed you, does he realize that the agreement he entered or whoever has entered has been struck down by Supreme Court?
Then after this
Now
renewal.
the question is, unwittingly, you may have a better case than this. Because what I was discussing you, that you go to the stage where you want, stage of issuance of so-called. But whether you will rely on second renewal or third renewal or first renewal, that is your choice. But I made this comment not as a I'm not adjudicating.
Yes.
Goa Foundation citation, Justice A.K. Patnaik. And that was in, I think, 2009.
Subsequent is common cause.
No.
First is Goa Foundation.
That has settled the law.
That was not.
That second renewal.
It's fairly issued.
Second renewal after this is not permissible. So now, if you want to rely on that, you rely on that. No difficulty.
That was also.
So by relying on Annex B/3, you can issue notice. I have no. Why should I comment on that? Correct. Because here the issues raised are that lack of opportunity of hearing, all these things. In that context, I looked at the original lease document. Original lease document is definitely not a partnership firm.
Yes, partnership. One line we missed to read on that.
No. At least I have not missed. So when you say we, two of you and me, so exclude me. I have not missed it.
One line, last line.
While reading, I read with some consternation and intent.
2014, article 6 STC.
No, 1 second. Putting 6 SCC. Larger bench. Because as I made it clear, Mr. Lenka, it will be an open remand. I will not observe anything. That is how I said that Mr. Palit may not like it.
No.
But now you have to decide at what stage. Because that would be fair to both of you. Because later on you will raise the issue that court has not directed, court has directed.
So let there be no observations. Let it be an open remand. From that stage of issuance of demand notice.
So I will not comment on the demand.
No, nothing.
One thing.
Let it be open, all contentious.
Only one submission, madam.
Yes. No. Have to check because you have said this. Now suppose I do not know. You may stick to this. But my difficulty would be that after Goa Foundation, whether I should look at
Goa Foundation came in 2014.
Yes.
But this second renewal was up to 2000.
Mr. Lenka, all second renewals have been declared to be bad in law by Goa Foundation. It has to be prior to 14 only. Because after 14, there is no question of concept of second renewal.
But this lease was up to 2013 and we operated. When the third renewal application was made, they rejected.
Second renewal, first renewal, research, and all second renewal. On your own swing, Annexure B/3 is second renewal. It is not first renewal. B/3.
Second renewal.
First renewal. If at all you are suggesting.
Second renewal, it was up to 2013, my lord. And we have already.
Because I am having the book, you are not now having the book.
I have to verify whether that judgment is retrospective or not.
No, verify you. Sir, much water has flown.
By that time, we have completed the lease.
Because anyway, 14th তে বইটা এটি আছে এসসি আছে তাহলে আপন দেখে আনো দিন লাইব্রেরি আছে you need not worry about that. The reason being I will not observe anything. But since it has popped up, so the issue has cropped up. जी आपको brief कले section 2 रे he must be from the mining department. He must know what is it. This has a widest ramification as far as because you see it was discussing Goa, not Odisha. And there comes the issue of illegal mining. if second renewal is held to be valid, then it cannot be a legal money. So many aspects.
Justice Goda, if your lordship remembers, Honorable Justice Goda had taken a similar view while in the High Court, but it never fructified in a judgment.
No, Mr. To be fair, Mr. Pali,
He didn't deliver the judgment.
to be fair with the government and the mining lease holder, the issue is that it was the usual practice.
My lords. And
nobody thought in that way.
Suddenly,
you cannot say that they did it
illegally. Then fly-by-night operators. No, they were not fly-by-night operators.
That was the practice. Fourth, third.
There might have been an infraction of the mining.
I have to even prior to the coming of to constitution, the leases given by the
erstwhile kings
like Tata.
And they were also regularized. They were also regularized by the coming in Mines Act Asla Pare, they were regularized under the main act. I have argued a few matters in that.
No, what actually, I mean, Goa Foundation has done is a fabulous job. A judicial interpretation that it stopped there after all. Because till that day,
second renewal.
Just imagine 2015. How many mining leases have been renewed by their
almost all in the Odisha at least.
What country?
At least
in Karnataka, Goa.
In Odisha, at least all. Hardly anything was there without.
That was the practice. Because I was at the receiving end there. Because I had to
exactly where Mr. Lenka is standing today.
No, Lenka is not handling that problem.
No, that issue was your archival handling.
So now the problem is, then I had to, in fact, we were at our wit's end. Suddenly this has come, then no. So we stand.
Well,
that.
And then the auctions also happened in that time.
Thereafter,
95 Act
came much after. Thereafter, amendment came.
2015 Act came, and then the auctions happened. And
there are some provisions of amended Act has been tested from
again. That was also
Justice Rafiq. Then
Rafiq and Justice Rafa, BN Rafa, Vishwanath.
Then Justice
Vishwanath Rafa tested. Then Justice Muralidhar also heard it. Justice Muralidhar heard it for quite a few.
Justice Narasimha argued as the lead counsel.
As he was there.
Now other matter is being argued. Some of the matters are remanded to by the Honorable Chief Justice. I think he has pronounced one. One by Justice Sarangi and me.
Justice Sarangi also had a case.
Somebody has a what is that called? What is that exploration? What is that called? Mining lease. Before getting
prospecting
license.
Prospecting.
Now, what is prospecting?
Then now the entire issue is going on whether the ores belongs to whom, the subsequent lessee or the raised ores beyond the time period.
State anyway, ଆପଣ ଦେଖିପାରିବେ ସେ ମୁଁ ପଢି ଦଉଛି Section 8(2) of MNDR Act permitting only 110 renewal option for a period not exceeding 20 years. Having said option, presently leases renewed from 22/11/1987 to 22/11/2007. Please mark the date. 11/87/2007, 20 ବର୍ଷ, first renewal. Section 8(3) permitting a second renewal for specified minerals, that is those not mentioned in Schedule 1, Parts A and B, but conditions in 8(3) for second renewal not having been fulfilled. Held, said illegal mining leases cannot continue beyond 22/11/2007. So 22/11/2007 was struck down in 21/4/2014. ଆପଣଙ୍କର ଏଟା କୋଉ ଡେଟ୍?
ଆମର ଥିଲା 2013 ଲାଷ୍ଟ
13 ଲାଷ୍ଟ
ଏଟା 94
yes
94 ରିଲିଜ 94 ରିଲିଜ ଡିଡ୍ ହେଲା 95 ରେ
That was a turning point actually.
2nd June 93 to
That
1st June 2013.
prompted the new legislation also.
Also, then common cause, Justice Lokur's observation
Is common cause.
for second renewal, because this aspect was not earlier actually noted that what would happen to the because automatic renewal does not mean the automatic clearances. So that was the concept developed in the Goa Foundation. You kindly read it. Kindly just read. I had to interrupt you because
Whereas, second part, whereas the minerals in the land in respect of which the second renewal of mining lease has been applied for belongs to government and the land is at their disposal. Whereas the applicants being a partnership firm registered in India, whereas the applicant by themselves or with any person joint in interest with them do not in respect of iron and manganese related group of minerals held such area in the state as with the charge area over which the second renewal of mining lease has now planned asked for will exceed 10 square kilometers. Then last. Therefore, next paragraph, last paragraph, I'm reading. Therefore,
whereas
the
actually କଳା ପ୍ରଥମଟା ଏଥିରୁ ଜଣା ପଡୁଛି କି ପ୍ରଥମେ କେବେ ପୂର୍ବ ରିନ୍ୟୁଆଲଟା କେବେ ହେଇଥିଲା?
ପୂର୍ବଟା ହେଇଥିଲା that is from 1653 to 1973. Then first renewal was
just 1 second, sir. এটা লিখি দিই। लीज ହେଲା 1653
2653 to 1663
20 ବର୍ଷ
20 ବର୍ଷ. Then first renewal for another 20 years 2673 to 1693.
Yes.
Then second renewal for another 20 years 2693 to 1623 to 2030. Sorry, 2030.
ଆପଣଙ୍କର ଏ ପିରିୟଡ ଅଫ ଡିମାଣ୍ଡ
My lord?
Demand period.
Demand period, my lord. I've given in the additional affidavit. That is annexure F/3 of my additional affidavit. That is period 2000 or in excess of approved 2001 to 2010 to 2011. Annexure F/3.
Sorry? Demand period ଟା କେବେ କହିଲେ?
2001 ରୁ 2010-11.
କେତେ ତାରିଖ 2000 ଆଚ୍ଛା ଡେଟ୍ ଛାଡି ଦିଅନ୍ତୁ।
ଇୟର ଟା
ଆପଣଙ୍କ ଡେଟ୍ ବି ଅଛି 2011।
ଆଜ୍ଞା। Annexure F/3 to my additional affidavit. That is the demand affidavit.
After this 21/7/94 order,
yes,
did you execute any document?
21/7/94
ଯୋଉଟା ଆପଣ annexure B/3
yes. That is
agreement, tapare lease hela.
Seita hala pa annexure 1 to the writ petition. I have also annexure 1 to the writ petition.
ଏ ଯୋଉ HG ପାଣ୍ଡିଆ ଆପଣ ଦେଖୁଛନ୍ତି annexure B by 3 ରେ HG ତ
SD. Hargobind.
HG.
HG.
HG ସେଟା ଦୁଇଟା ଟିକେ ଲିପି ଯାଇଛି ନା
Aye. Annexure 1, page 22, your lordship may can see. Huh?
21
Aram 22.
ସେ HG ପାଣ୍ଡିଆ କଣ ନାହାନ୍ତି ଏଥିରେ ପେଜ 21 ରେ ରିଟ୍ ଆପ୍ଲିକେସନ ରେ
He is dead now. But
ନା 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 ଏ ମାନେ 94
he died in when the first renewal was in operative. He died on 7/2/1989.
HG died.
Yes.
ତାହେଲେ ଆପଣ କେମିତି ଆପ୍ଲିକେସନ ନେଲେ ତାଙ୍କର ଡେଡ୍ ପର୍ସନ
The dead person application ଦେଲୁ ପରା ସେ partnership farm. ତ partnership farm apply କଲେ
ପଢନ୍ତୁ
ଆଜ୍ଞା
ପଢିବେ ନା ଅର୍ଡରଟା ଦେଖନ୍ତୁ whereas Messrs HG Pandya
yes
and others have applied for the state government.
ସେ ନାଁଟା ତାଙ୍କର partnership farm ନାଟ ଦୁ reading I'm reading it. Whereas the applicants being a partner
Because death of a partner to ଆଉ ଗୋଟେ consequence anyway ସେଇଟା ତ I'm not going to those things.
94 ଏଇଟା ହେଲା 94 89 ରୁ ସେ ମଲେ
No, why you have because death of a partner is a consequence ଆପଣ partnership act ରେ ଦେଖିବେ.
The partnership act କହୁଛି ଯେ that I have brought also your lordship and see partnership not created by status section 5 of the act.
Death of a partner ର consequence କଣ?
If a partner dies, the surviving partners may carry on the business by forming another partnership. In such a case, they will have to account for the share of the deceased partner to his legal representative.
ଟିକେ just slowly ପଢନ୍ତୁ fast.
If a partner dies,
ତା ପରଟା slowly.
The surviving partners may carry on the business by forming another partnership.
Yes, another. That I was asking you. You are dot on that point actually. So,
but here the same partnership.
No, HG Pandya died. Partnership is a different kind of business association. Partnership is not like company that it carries forward. So there is a specific statutory provision which you have found out.
Yes, section 5 your lordship says.
Say 5 itself says by another partnership because
I am reading from the comments. But section 5 says partnership not created by status.
ସେଇଟା ଆପଣ କମେଣ୍ଟଟା ଦେଖନ୍ତୁ ପାରା 4 ଯୋଉଟା just ମୁଁ କହୁଥିଲି.
Yes.
Partnership firm is not a legal entity.
Yes.
That's a Supreme Court decision. Which we based our discussion for the almost an hour or more than that. We discussed on that only actually. Then farm name is only a compendious name given to partnership, and the partners are real owners of the assets, and partnership firm is not legal entity. No, Mr. Lenka, your objective of showing this annexure 1 and P by 3. What is your, what turns on that? What turns on that? What is your submission on that?
The prayer of the writ petition, if your lordship go to the prayer of the writ petition, your lordship will find its sole prayer is that legal heirs of the deceased certificate debtor have not been lawfully substituted in the proceeding on issuance of prior notice. But when it comes to a partnership firm, the question of legal heir does not occur. And all the parties, your lordship, just a minute.
Court handle
Court.
In case of a legal, it comes to a partnership firm.
Yes.
Legal heir does not arise. It court handle.
Section 5. Partnership not created by status. Fourth definition of partnership. Partner, firm, and firm name. Partnership is the relation between persons who have agreed to share the profit of a business carried on by all or any of them acting for all. Persons who have entered into partnership with one another are called individually partners and collectively a firm. And the name under which their business is carried on is called the firm name. I will take your lordship to definition section 2E.
Yes.
2E. Your lordship may see 2E. Expression used but not defined in this act. That is Partnership Act. And defined in the Indian Contract Act 1872 shall have this meaning assigned to them in that act.
So which expression you are saying, not defined?
Whatever expression your lordship
not defined in the act. Which expression is not defined, you will go to a Contract Act.
Expression used but not defined this act and defined in the Indian.
So definition partnership is defined in section 4.
Yes.
Yes.
What I submit, my lord, that the partnership firm is a purely on a contract basis, covered by under the Indian Contract Act. Only to share the profit in their business, only to share the profit. Nothing less or nothing more. That is my submission so that to the annex definition 2E. Here, my lord, all the partners appointed power of attorney holders.
Suppose you are reading section 4.
Yes.
Section 4 will prevail or Contract Act will prevail? According to you, reading 2E. 2E read with 4. Which will prevail? So if you read 2E and 4, 4 will prevail.
4 will prevail.
So you have to go by 4, not by 2E.
Something not provided in 4, then contract.
Obviously. Anything not provided is a contract.
Anywhere else in that? Contract that will be.
Here what happened, my lord? All the partners appointed one power of attorney holder. Power of attorney holder, when the demand notice sent to the power of attorney holder,
all the partners excluding HG because he died.
But his legal heirs were there.
ସେଇଟା ଆପଣ କୋଉଠୁ ଆଣୁଛନ୍ତି ମୁଁ ସେଟା ପାଉନି
ରିଜେଣ୍ଡର ଆନେକ୍ସର
ନାଇଁ ଆପଣ ଲିଗାଲ ହେୟାରଟା ଯୋଉଟା ଆଣୁଛନ୍ତି ପାର୍ଟନରସିପ ଆକ୍ଟ ରେ ପଢିକି ପାର୍ଟନରସିପ ଆକ୍ଟ after you read then your concept of because your concept of partnership and 4 are different.
No, nothing different, my lord.
Because no, read sir. Both author पढ़ो.
Definition of partnership.
Persons खाली पढ़ो.
Partnership is the relation between persons who have agreed to share the profit of business carried on by all or any of them acting for all. That's clear.
So then need persons.
Then persons who have entered into partnership with one another.
So who have entered with one another after death of HG?
they form another partnership, taking
But
the legal heirs, taking.
But the applicant is HG.
No, your lordship may see annexure 1 to the writ petition is not HG. That is one of it is not.
B/3 sir, ଆପଣ B/3 ସାଇଡ୍ କଲେ ମୁଁ କାଇଁ 1 ସାଇଡ୍ କରିବି ମୁଁ କୋଉଠି ପଢିବି ଆପଣ ନିଜେ B/3 ଆପଣ ରିଲାଏ କରୁଛନ୍ତି
ପାର୍ଟନରସିପ
B/3 ରେ ଆପଣ नो ଦେଖୁନାହାନ୍ତି HG ମୁଁ ସେପେ HG କୁ ଖୋଜୁଥିଲି ଆପଣ ବିକଜ G ଟା ଦେଖା ଯାଉନି ତା ଦେହରେ
ଆଜ୍ଞା
G ଟା କଟି ଯାଇଛି but HG ହିଁ ହେଇଥିବ
sir I am having the genealogy also. I have brought the genealogy.
no ସେଇଟା ତ genealogy I am not asking sir.
No, all these are his sons and daughters.
So the agreement in 3/2/1995
Right.
HG is not there.
HG is not there.
So if you are relying on section 4,
yes,
persons who have entered into partnership with one another.
Your lordship may see. The farm name is HD Pandya and others. The name of the farm, partnership farm. Your lordship may kindly come to page 22 of the annexure 1.
Yes.
Middle. All the names are there. 21 starts. 1. Sri Kanta Prasad Pandya.
Author page ta koibe
21 man. Annexure 1.
মানে जो running page 21 কହୁছো
Running page 21. Annexure read petition or running page 21.
ଆଜ୍ଞା ସେଟା ତ ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି ସେତେବେଳେ ଆପଣ ସେଟା ଯାଉନାହାନ୍ତି ତ ସେଥିରେ ସେ ଲିଷ୍ଟରେ HG ନାହାନ୍ତି ନା ବଟ୍ ଆପଣ B/3 ଦେଖନ୍ତୁ B/3 ଦେଖନ୍ତୁ
ହଁ B/3 HD
B/3 ରେ ଆପ୍ଲିକାଣ୍ଟ ଦେଖନ୍ତୁ ଆଉ 21 ରେ ଦେଖନ୍ତୁ କାହାକୁ ଆପଣ ଦେଇଛନ୍ତି ସେଇଟା ମୁଁ ଆପଣଙ୍କୁ କମ୍ପେୟାର କରୁଛି କମ୍ପେୟାର କରିବା ପାଇଁ କହୁଛି
A/3.
But anyway, I am not going to. I will not be analyzing those.
No, A/3 is the application. They are HG Pandya. HG Pandya is not there. Then B/3.
କାହିଁକି ସେଟା ସେମିତି ହେଲା I am not going into that.
Yes.
ଆପଣ ଦେଖନ୍ତୁ A/3 ରେ A/3 application date ଦେଖନ୍ତୁ.
Yes. January 92.
So HG is no more there.
No, 89 he died.
I mean, I think that's no dispute, Mr. Palit. HG died in 89?
Yes, he died in it.
Okay. Now can you just look at annexure B/3 and A/3?
Yes. A/3 is the application.
Date?
2nd January 1992 in the top, my lord.
So kindly just mark who has signed for Hargobind Pandya.
Signed by the power of attorney holder. One of it is
So this is what I was trying to tell you.
Yes.
That after death of the partner,
they formed another partnership.
So where is that? Seta pasei partnership ta code seta. There is a problem then, Mr. Because then Mr. If you read section 4 is precisely, you can check this decisions, of course. You see, I will not be referring to that. 2003 2 SEC. The knowledge associate, if I can note down.
2003 SEC.
Volume into bracket 2003. Volume 2 SEC 349.
2002 volume 3 SEC.
Yes.
3. There are 3 volume 2.
Page by lord?
Page 349.
Yes, sir.
2003 SEC volume 2.
Again. The style of writing is into bracket 2003 and 2 SEC 349. Partnership firm is not a legal entity.
Yes.
Because your case is that since it is a legal entity, Hargobind Pandya, after subsequently they have found another partnership firm. So then look at another decision, 2003 volume 3.
Yes, sir.
229.
SEC.
2003 volume 3 SEC 229.
Madam.
partnership farm name is only a compendious name. And the partners are real owners of the assets, and partnership farm is not legal entity. So after death of one of the partners, what would happen? That would be in the partnership deed itself. Whether it will devolve, the property will devolve other partners, excluding the legal heirs or including the legal heirs. There's a possibility. Then another decision. It's same as the earlier AR 1980 Supreme Court 176.
176.
AR 1980 Supreme Court 176. So if I have understood, you are citing annexure A by 3, annexure 1, B by 3 to say that those who are in the partnership, they have been noticed. No one else.
No. No, we have noticed only to the power of attorney holder.
The farm.
Power of attorney holder, your annexure.
Then even if you are exhibiting annexure B by 3 now, showing marked as annexure B by 3 also, still you are saying that you did not issue a notice to anyone else.
No, we issued notice to the farm, and the farm represented by the power of attorney holder. And your lordship will see.
Then Mr. Lenka, then there is no improvement. Whatever we discussed on the last occasion.
Yes, sir.
If you read with section 4, with those case laws, because it belongs to the individual partners, it cannot be the power of attorney holder.
And the agreement has been executed with the government, that is the power of attorney holder. Annexure 1 to the writ petition, my lord. Annexure 1 to the
Somebody signing the agreement cannot
Yes.
own the property. Must understand that.
And here, my lord,
Even one of the partners cannot own the property. It is all. That is very clear in these three decisions. Very fundamental. And most fundamental is that it is not a company. It is not a legal entity.
Yes, sir.
If it is a legal entity, then you can argue that the power of attorney holder represents the legal entity.
Power of attorney holder.
Power of attorney holder, if you read section 4, read with section 2E, section 5 also. Because section 5 clarifies only section 4 or in supplement to read it again. Read 4. The three decisions I have given you is in section 4.
That I'll go through, my lord.
No, you did not, because I am not going into that.
Yes. The definition of partnership.
Power of attorney concept बिल्कुल नहीं अपना representing the partnership firm. Your problem is that what you are reading अपना order टा पढ़ो तो पढ़ो. ये जो CPC पढ़ो तो देखिए.
That is order 3. Rule 1 and 2. Order 3, recognized agents and pleaders. Appearance, I'll go to the 2, recognized agents. Order 3, Rule 2.
So Mr. Lenka,
Yes.
notice to pleader is not notice to the party as far as administrative law is concerned. Law is not the problem. In accepting it, suppose now I issue a notice is issued to Mr. Lenka. Is it a notice to the government? It is not.
No, we have issued
You are
the
accepting notice on behalf of the government. But you are arguing the converse. If notice is to be issued to Mr. Lenka, the bond
notice
special bench का
Order 31.
नहीं sir.
Special bench.
keyboard जहाँ केला असेल किती पडलं तू continue to legislator field.
My lord, only 31, 3-1. My lord, any date before vacation because matter is most urgent one.
Sir, ଦେଖନ୍ତୁ already ଆମେ vacation next week ରଖୁଛେ ପାଖାପାଖି 120
120 near about.
120 ରୁ ବେଶୀ ହବ ସେ କମ ହବ ତା ଭିତରେ 4 ଦିନ ଭିତରେ ଆପଣ ବେଶୀ adjust କରିପାରିବେ ତ ତା ଦେହରେ ତ ଏଟା these are not the only matters.
My
is the directed to be listed ତା ଦେହରେ memo ଅଛି regular filing ଅଛି order fee ଅଛି ସବୁ rest
Top of.
ଯେଟା କମ୍ପ୍ୟୁଟର କରୁଛି ଆପଣଙ୍କ ଇୟର ଅନୁସାରେ ସେଟା ସେ ସଜାଡ଼ି ଦଉଛି ପ୍ରଥମେ ଫ୍ରେଶ ତାପରେ ଅର୍ଡର୍ସ ତାପରେ yes
32 I love.
32 so yes question there the before version जाऊँ are we
32. Item 26 lots.
26
ଗୋଟେ adjournment petition ଦେବା ପାଇଁ interview order ଥିଲା ଗୋଟେ vacation ପରେ yes lots.
you have Mr. J. Swai.
Yes lots.
The J. Swai for the petitioner. You can go ahead, Mr. Kush. 26, Mr. J. Swai for the petitioner. Is it party back? The matter is for orders.
Yes, my hearing ପାଇଁ ଥିଲା
The matter is listed for orders. Paucity of time, interview, and the matter is mentioned by the Lord Counsel for the petitioner. He refers to the order declared quota. What do you?
Yes lots.
Declared 15 to 2026. Thereafter on Pondereto, 10 submits that the country for directing adjournment of the matter. Then you have a partnership. How they call it? Contract. Or a attorney. So that planning is good. Partnership contract. Yes. Adjournment of the matter before the Lord family court. We reiterate stop. Correctly, directly. Already capable to
First week is second week of July lots.
The matters have been listed in the work policy. Are the mentioned on that?
नहीं किसी को नहीं
Which has been listed in the week commencing 6/7/2026.
yes lots.
Upon a prayer being made before the Lord court in season of the CP number.
CR yes sir.
Execution.
Yes sir.
EX CR dot P dot number office of Korea Purchasing. Taking adjournment. The same shall be adjourned. Beyond 13/7/2026. You a date beyond 13/7 for that beyond 13/7/2026. As will be convenient to the allotted quoted season of the matter.
Yes.
List has shooters.
But it's a issue in 6/7. Yes.